And I'm also, is Sam's already? Okay, sorry. We're expecting some guests from the district, so I wanted to introduce them, and I'll do that as they arrive. There is no supplementary agenda today, and I'm asking if there's a disclosure of any pecuniary interest by any of the committee members. No? Okay, great. So the way we're going to do this is, I know Mr. Cutting is going to speak to item 7A, Mr. Ross, and Mr. Ross will speak to item 11A, and I'm going to have them speak as the item comes up so we can keep everything together, flowing properly. And so at this point, I just want to deal with item 4C, which is nowhere else on our agenda. And so I believe that I don't know if Ms. Stromme is here or Stefan. Please come up.
Good morning, Madam Chair. Nice to see you again this week. It's been a couple of times.
Yes.
Members of committee, staff, my name is Stefan Szczerbak from Landscape Inc., 104 Kimberley Avenue. I have a unique request for the committee today, and we're representing Linda Stromme, who owns a unit at the Lake Joe Club and part of Muskoka Condominium Corporation 41. She purchased a unit with a large covered deck, a covered porch with a deck that was constructed without a permit. The structure itself has been in place for well over 15 years. She purchased the property probably about a year and a half, 2 years ago. And she was, an order to comply was issued, and she fully wanted to make sure and legalize the structure. She went ahead and the title insurance company was supposed to take care of a minor variance application, and she was moving forward to rectify the situation. Unfortunately, the title insurance put this file at the bottom of their desk, bottom of their pile, and she called me at the last minute to try and ensure that this minor variance were to move forward so that charges wouldn't be laid through the building permit. So, I mean, she has been really trying to work forward to get this done. The minor variance application was submitted to the Committee of Adjustment. The Committee of Adjustment unanimously supported the minor variance application. So the next step, because the property is zoned waterfront commercial, there is a provision in your site plan agreement, the site plan policy, that any structure over 600 square feet requires an amendment. This structure itself is approximately 800 square feet, so about 217 square feet over what would normally be permitted. And again, she wants to be fully compliant. She had us immediately put together the site plan agreement. Unfortunately, the Muskoka Condominium Corporation required approval from ClubLink because there's some issues between the two of them at this property. So after repeated attempts to ClubLink, they just refused to acknowledge the fact that they needed approval in order for Muskoka Condominium Corporation to authorize us to submit the application. So after getting some lawyers involved, and she's just been trying to get this thing resolved, working through myself and the lawyers, she really has hit a wall. And she wants to finish this. She wants to go to the building department to finalize this building permit. And as a result, she, speaking with staff, the suggestion was to come to the committee to see if the committee would be open to providing an exemption for this situation. Again, the structure's been there for 15 years. She purchased it. She's wanting to work through this. She's wanting to legalize it. But she unfortunately has hit a wall between a squabble between Muskoka Condominium Corporation and ClubLink. So my request today to the committee is to respectfully request an exemption to your site plan agreement for this situation. Normally, the site plan application would be there in case there's additional plantings required, if there's anything that's needed. In the staff report, they did advise the Committee of Adjustment at the time that there's no vegetation, there's plenty of vegetation there. The structure was built over an existing deck. There was no vegetation required. It's somewhat of just a formality, and she's caught in this. So again, I would respect the committee's indulgence to seek an exemption to your site plan agreement and waive the requirement so that she can finalize this structure.
Okay.
Thank you.
Thank you. Is there anyone else who wants to speak on this? I think so. Committee, anybody have any questions, comments? Councillor Nishikawa?
Thank you. I'm not sure who this would be to, so I'll just direct it to you. Thank you. My concern is that we need to hear from the condo association or the regulating body there. I, of course, was in that committee of adjustment, so I don't know if they receive further information than we did this morning. At this time, without that information, it's very curious to me that a structure that size got built, first of all, without a permit, but when generally in a condo situation, all sorts of rules and regulations come into effect, and I would be concerned that others would see this as an opportunity to go forward and do the same. So I can't say at this point how I could vote.
Thank you. Anyone else have any comments? Yes.
Madam Chair, if I could just respond to that. The Condo Corp did provide an authorization for the minor variance. So they already know that this exists. They're already aware that it exists. The thing is we're stuck because she can't submit the application because the owner needs authorization to sign it. So they're completely aware. And I believe, and maybe Mr. Pink can help, I think there were 4 or 5 other similar situations that happened and that they've all been rectified. I think this is one of the last. And again, the construction was done 10 plus years ago. And many of the orders to comply have been all addressed. And if I'm not mistaken, this might be one of the last ones.
Mr. Pink, would you like to comment?
Yes, I believe it would be, through the chair, thank you to committee. Generally public information, there were a number of orders issued by our Development Services Department regarding construction without a building permit on this property. A number of those owners did go through a minor variance process, and I believe they were all approved. This, I believe, is one of the only ones that is over 600 square feet in size, so our site plan control bylaw triggers that it must require an agreement, and hence the situation that they're in. The others, I believe all the other construction was entitled to a building permit after the minor variance approval, as they were all under 600 square feet in size and didn't trigger a site plan agreement. So just to put this in a little bit of perspective, committee members are probably fairly familiar when we sometimes approve zoning amendments, we approve them conditional on a site plan agreement, and we bring bylaws to you imposing site plan control because the site plan control bylaw says you're exempt. This is the opposite. A development requires site plan approval, and a property owner has come to you asking to waive it because of a bit of a technical difficulty in obtaining signatures from the owner. It's a unique situation due to the condominium ownership structure. So, happy to answer any questions, but hopefully that helps clarify.
Councillor Edwards?
Yes, I can verify that. Being on the committee of adjustment, there were a number that came forward. They were all existing decks, and they just built over them. So there's no vegetation coming as the agent says. It's over 15 years old. So it's just a case of just clearing something up. And on the other ones, we did get letters from the condo corporation said they had no objections. And I believe, as you said, it was Club Links who are there that they wouldn't sign off on it, but the condo units did sign off.
Councillor Jaglowitz?
Yes, through you. I'm just confused. The condo corporation, this is part of a condo corporation who are in agreement to sign off. Why is Club Link involved?
Through you, Madam Chair, Club Link's involved because I believe Club Link's the owner or responsible for the common elements. So there, the lands along the waterfront, along the side, and any other lands outside of the Muskoka condominium. So there is some type of an agreement that when the condo corp wants to redevelop there's the possibility that it might be taking away some development rights that the Club Link have. But in this case, again, this development's been existing, it's there, there's agreements between the two of them, and the Muskoka Condominium Corporation, although they have the authorization to sign it, requested us to go and seek support from Club Link.
Councillor?
Supplementary, so is it possible that this was built on common elements rather than on the condo unit that the owner has?
Through you, Madam Chair, it's possible, but that has not been determined. You know, at this point, there was no survey out there. So I know the question was raised. A surveyor hasn't been out there, but again, the deck exists, the structure, you know, exists, and that has not been formally determined at this point. And I think that's why the hesitation that Muskoka Condominium Corporation required Club Link to say, if you're okay with it, we're okay with it.
Go ahead.
Possibly one then through to staff. So the reason you're asking or wanting Club Link to sign off is because you have a concern that they have an interest. Is that true?
Mr. Payne?
Through the chair, I don't believe staff has asked for Club Link's input. I think our research, I believe, indicated it is on the unit itself. So the Condominium Corporation does require the sign-off. I believe it's the Condominium Corporation which has asked for Club Link's permission. I think there's something going on between those two parties with respect to remaining development rights. And there's been some discussions going on, and there's probably a bit of a backstory there that we're not privy to. So.
That's correct, yeah.
One last one. So therefore, you do not have a permission, a letter from the condo corporation. That's what the issue is now.
Through the chair, what I understand is that in the Condominium Corporation, we did require their authorization for the minor variance applications. Those were received, so they are aware of it. They're all complicit in it. And so we have that authorization, and from what I'm hearing from the agent, they're fine with submitting the site plan application. They just feel they need Club Link's blessing, and that seems to be the hiccup. And I can't explain why that's the case. That's between those two parties. At the end of the day, what I can say from our perspective, I would look at it as what's the benefit of the site plan agreement and whether we need it or not. As noted in the staff report, and the Committee of Adjustment didn't impose it. It's an existing structure, about 15 years old, on an existing deck, will not require any tree removal. We didn't feel it was necessary to oppose additional plantings or any stormwater management measures. So essentially, I think what the agent indicated, I would generally agree, it's essentially will result in a paper exercise. So I think staff's generally comfortable with waiving it, but that's certainly up to committee and ultimately up to council if committee sends direction to council.
Mayor Harding?
Thank you, and I appreciate our director's comments. We're talking about a site plan control to control development, to do vegetation in and around a building that's been up there for 15 years. It's moot. There's no reason for us to do this, to actually even impose it, except for our law says over 600. This is why we provide exemptions, so I do not need site plan control on this property.
Thank you. Councillor Nishikawa?
Thank you. I have a question which I don't think can be answered, but I do have a concern that if a corporation or Club Link and or even the condo knows that there are expectations from this municipality and now we're waiving those, and they still have a challenge down the road, I just would hope that there's no reason for, and I'm saying this in any future condo situation, that there's no reason that that corporation can come back and say the municipality shouldn't have done this because we still have outstanding issues. That's my concern. But otherwise, I agree with everything else.
So if I might chime in, being a board member on a condominium, I think this is, what our director has said is, we don't need the site plan because it's done. The difficulty is between Club Link and the owner. If Club Link feels the owner is on their property, and I'm going to guess that might be the issue, that's between the two of them to work out. It has nothing to do with the municipality. That's my humble opinion. Are we, any more questions? Okay, so Do we have a resolution? Sorry?
Through Chair.
Go ahead.
So nothing's been prepared, obviously. We just received a delegation request. What option I can suggest, if committee members are supportive, we can bring a resolution to the next council meeting recommending or have a bylaw that the site plan be waived, if that's the consensus of committee.
Okay, thank you. The consensus of committee? That is the consensus, Mr. Pink.
Thank you very much.
We are on to our public meetings now, and the first one is Carr, and Mr. Sharp, if you would take us through it, please.
Good morning, Chair Bridgman, members of Planning Committee, colleagues, applicants and agents, and members of the public. The first applications to be heard are Official Plan Amendment Application 53, Consent Application B/52/19/ML, and Zoning Bylaw Amendment Application ZBA-48/19 in the name of Carr. The applications have been submitted concurrently. The subject property is known municipally as 3164 Muskoka Road 118 West, Unit Number 21. I would direct committee's attention to the consent sketch, draft bylaw, and draft official plan amendment beginning on page 31 of the agenda package. The purpose and effect of the applications is as follows. An application to amend the official plan of the Township of Muskoka Lakes has been submitted, along with consent and zoning bylaw amendment applications to create one new lot. Firstly, Official Plan Amendment 53 is required to implement site-specific development policy as the subject lands are partially located on Silver Lake, which is deemed to be an over-threshold and highly sensitive water body as per the official plan of the Township of Muskoka Lakes. Policy B.6.24 identifies that no lot creation will be permitted on water bodies identified as being over threshold and highly sensitive unless the subject lands are connected to municipal water and sewer services. The proposed amendment will permit one additional lot to be created, and development policies will include implementation of the recommendations of the scoped site evaluation report and water quality impact assessment prepared by Beacon Environmental and dated December 2019. Secondly, consent application B/52/19/ML proposes to create one new lot and grant a right-of-way. The proposed severed lot is vacant and fronts onto Silver Lake. The retained lot fronts onto Lake Rosso, more specifically Arthurlie Bay, and also abuts Silver Lake. It contains 2 land-based dwellings, a number of land-based outbuildings and trailers, a 2-story boathouse with an upper-level sleeping cabin, a single-story boathouse and docks. The portion of the retained lot abutting Silver Lake contains a snowmobile trail. A right-of-way is to be granted over an existing driveway/laneway on the retained lot in favor of the severed lot. Thirdly, zoning amendment application ZBA-48/19 will permit a new lot to be created. The severed lot is zoned waterfront residential WR4, and the retained lot is partially zoned WR4. In the WR4 zone, new lot creation is not permitted without a zoning bylaw exemption. The purpose of bylaw 2019-164 is to provide an exemption from the minimum lot requirements to permit a new lot to be created. Bylaw 2019-164 will permit new lot frontages and lot areas for the resultant severed and retained lots as follows. The severed lot is to have 1,070 feet of lot frontage and 19 acres of lot area, and the retained lot is to have 350 feet of lot frontage and 60 acres of lot area. Please note that the measurements regarding lot frontage and lot area have been reduced in bylaw 2019-164, and reducing the measurements will ensure conformity with the bylaw once the new survey has been prepared. It is anticipated that a new survey will show greater amounts. Please see Schedule 2 to bylaw 2019-164. The purpose of the bylaw is also to restrict the location of a dwelling, as well as land-based accessory buildings and structures, excluding sewage disposal systems on the severed lot, to a development envelope identified by Beacon Environmental. Please see Schedules 3 and 4 to bylaw 2019-164. The purpose of the bylaw is also to restrict the location of shoreline structures on the severed lot to a development envelope identified by Beacon Environmental. Please see Schedules 3 and 4 again to bylaw 2019-164. In summary, the effect of the applications will be to permit the severed lot to be created, to implement site-specific development policy to guide the future development of the severed lot, and to restrict building and structure locations on the severed lot. Notice of this public hearing under the Planning Act was circulated 21 days in advance, and 4 submissions have been received to date. The first submission is by the District Municipality of Muskoka Planning and Economic Development Department, and it reads as follows. District staff would recommend a decision on the above-noted applications be deferred until such time a study is completed to the satisfaction of the Township of Muskoka Lakes, which verifies the forest types on the subject lands, and if hazardous forest types are identified, recommends environmentally appropriate mitigation measures in consideration of any natural heritage features or functions that also exist on the site, or directs development outside of these areas. Should committee or council wish to consider the above-noted applications, district staff would recommend that the appropriate development control techniques be used to direct development outside of any areas of wildland hazard risk identified on the subject lands by available screening tools, as well as to implement the recommendations of the below referenced studies relating to water quality, deer wintering, and fish habitat and species at risk. Notice of committee and council's decisions respecting the above-noted applications is requested. The submission goes on to speak to some of the analysis that was undertaken by district staff, which is important to the applications. The subject lands are located within the waterfront designation of the Muskoka official plan. It is our understanding that the purpose of the consent application is to create 1 new lot on Silver Lake and to grant a right-of-way for access, while the proposed zoning bylaw amendment is to permit the creation of 1 new lot in the waterfront residential WR4 zone. The concurrent official plan amendment application is to implement site-specific development policies to facilitate the severance of 1 additional lot on Silver Lake, which includes the implementation of recommendations provided in studies submitted as part of the application. The Muskoka official plan, as amended by Official Plan Amendment 47, was approved by the province on June 28, 2019. The amended Muskoka official plan implements an updated approach to recreational water quality, where lakes are no longer classified as sensitive or over threshold based on phosphorus levels, but rather includes standard protection policies for all water bodies with enhanced protection policies for water bodies identified on the basis of several water quality indicators. Under the new policy approach, as the proposed severed lot has frontage on Silver Lake, the standard protection policies contained in section C2.6.5.2 of the Muskoka official plan would apply. These policies include a number of matters that are to be addressed through the implementation of site plan control, including stormwater management and construction mitigation, retention or restoration of vegetative buffers, and the appropriate location of buildings, structures, and sewage disposal systems. In this case, the submission of the water quality impact assessment prepared by Beacon Environmental Limited and dated December 2019, and the implementation of its recommendations as a result of the above-noted applications would appear to satisfy the policies of the Muskoka official plan. The Ministry of Natural Resources and Forestry has identified stratum 2 deer wintering habitat on the entire property, as well as unknown fish habitat along the entire frontage of the proposed severed lot. Available species occurrence data also confirm that the subject property may contain habitat for species at risk. These matters have been addressed through the submission of a scoped site evaluation report prepared by Beacon Environmental and dated December 2019, as well as the above-noted water quality impact assessment. The scoped site evaluation report and water quality impact assessment both conclude that the subject to the implementation of the recommendations of the report, appropriate conditions exist to permit the proposed severance. Staff would note that although potentially hazardous forest types were identified on the subject property based on generalized wildland fire hazard risk data provided by the Ministry of Natural Resources and Forestry, this matter was not addressed in the scoped site evaluation report. Section I 2.8 of the Muskoka official plan requires that the development shall generally be directed to areas outside of the lands that are unsafe for development due to the presence of hazardous forest types for wildland fire. Where development is proposed within hazardous forest types, it may be permitted where risks are mitigated. Within such areas, the municipality may request that the completion of a wildland fire assessment report to verify the wildland fire risk and identify required mitigation measures if required. Alternatively, township committee/council may wish to employ appropriate development tools to ensure the appropriate development of the subject property is located outside of wildland fire hazard areas by relying on screening tools that are available. And that is signed by Cassidy Fiore, district planner. The second submission is by Sandy Boss, who is a township building inspector responsible for servicing. Regarding the proposed severed lot, Mr. Boss notes that there is an ample area for an on-site sewage disposal system. Regarding the proposed retained lot, Mr. Boss notes that he has no record of an on-site sewage system serving the dwellings on the property. Due to weather conditions, it was not possible to assess the existing systems. He does note, however, that there is ample area for replacement systems. Mr. Boss recommends that the applications be approved from a servicing standpoint. The third submission is by Ken Becking, the Township's Director of Public Works, and the Public Works Department has no objections. And the fourth submission is by Catherine Stewart Cordy, who is an area landowner, and the submission is as follows. I am unable to attend the meeting on February 14th, so I would like to express my opposition as follows to the following possible scenarios. I have several concerns, first being that if the amendment is granted, it is unclear what the future will hold for the proposed lot on Silver Lake. It is possible that the lot could be then sold to a developer with intention to sever the lot into smaller lots. Since it consists of 1,070 feet of shoreline, further application could be made to the township to create 5 or more lots. If that were ever to be the case, it would invade on my family's privacy, as the severed lot is at the corner where the shore turns. All boat traffic from the lots would impact greatly my property. Secondly, although I was under the impression that no boathouses with actual slips would be allowed on Silver Lake, after speaking to planner Bryce Sharp, I was told that they are in fact allowed. I am concerned as to what the actual plan would be for the boathouse package in the future, particularly if, as stated above, the lot on Silver Lake was divided. Thirdly, I'm pleased that the road access to the severed lots is by Carr Road and not Stephen Road, and I'm opposed to any further future application to extend Stephen Road to these 2 severed lots. And again, that's by Catherine Stewart Cordy. Staff have prepared a detailed report for committee's consideration. I have no further comments at this time, and I'm happy to answer any questions that committee may have. Thank you.
Thank you, Mr. Sharp. Would the owner or agent be here to speak on behalf of this? Mr. Frommer, come on up.
Good morning and happy Valentine's Day. Steve Honor, Northern Vision Planning Limited, 109 Meadow Heights Drive, Bracebridge, Ontario, P1L1A4. I'm here representing the Carr family. There's 3 members, and they're all present here this morning for this particular application. I would like to thank staff, again, a very thorough report and a positive report on this application. So I'll just quickly go through PowerPoint presentation. We can go quickly through, I think, the planning framework. I think you pretty much know. I will make a comment on the Lake System Health Program, just to make the comment that that has certainly changed recently in the district official plan. However, it's still identified in the local plan that Silver Lake is over threshold and highly sensitive to phosphorus. And in terms of the zoning, there are 3 different zones on the property, and that's mostly because of the size, because of the status of the lakes under the local official plan. Silver Lake is WR4, the Lake Rosso frontage is WR1, and then there is a large interior portion of OS2 as well. So the proposed lot is considerable in size, over 20 acres and over 1,000 feet of frontage. There is an accompaniment, an official plan amendment, as well as a zoning bylaw amendment, and the zoning bylaw exemption, will permit lot creation on Silver Lake, but also limit the location of building envelopes for shoreline structures and land-based. Now, the reason for the proposal is it is family-oriented. I know it's not a planning reason per se, but I think it's important to know that Ted Carr passed away and left land to his heirs, I guess, and the one son would like to realize sort of the value out of that. The only way the family can afford that is actually to sever off a lot. So this is the outline of the property, and I think the next slide is just a little bit more detailed. It just zooms in a little bit. A large sever lot. On the east side, or the right-hand side of the drawing, is the Lake Rosso frontage, about 357 feet, and that's where there's existing development there in terms of a dwelling, 2-story boathouse, and another boathouse, and then there's a farmhouse located towards the bottom of that. You can see other clusters of buildings. There is a pre-existing farmhouse. This used to be a farm, actually, at one time. So this is, in terms of looking at the site characteristics, this is the snowmobile trail that leads down to Silver Lake. This would be on the retained lands. There's a 300-foot frontage of retained that's still on Silver Lake, and that is actually to retain the viability of the snowmobile trail. This is looking to the east. The slope is fairly moderate, but very heavily treed. Again, this is on the retained lot. And this is at the shore looking west. Again, you can see very heavy tree cover. Looking east and actually towards the severed lot and the severed frontage. This is the shoreline, again, very, very heavily treed, very thick. This is onto the severed lot. You can see the slopes. They start getting to be more extreme. There are some extreme slopes on the proposed severed lot. Beacon has looked at that and identified a satisfactory building envelope, but only for one dwelling. There may be the possibility that maybe there's another site, but they identified the prime site. The property is, in my opinion, not prime for development, and I think would be difficult to break up into the feared 5 lots that the neighbor was talking about. This is looking up into the property, and actually the photograph that I just took was the one to the right of this, and it slopes up, and it slopes up on the left. So there's a draw in between, or a small valley, if you want to call it that, where Beacon has identified that building could occur. But on each side of this are pretty precipitous slopes. They're hills. And this is looking down towards the water's edge. Where I'm standing is fairly level, and it drops off again to the water's edge. And this is in front of the proposed building site. This is the farmhouse that exists on the property, and this is actually in a waterfront residential zone, but it's about 600 feet back from the lake, 500 to 600 feet back from the lake. And these are some of the accessory buildings. There is a sugar shack off to the right, and there's a barn in the back. And that's, I know it's hard to see in this light, but that is a barn. It's been there for quite a number of years, and as I say, this used to be a farm. It still is used to a degree. They do maple syrup production. This is the dwelling down near the water on Lake Rosso. And this is the 2-story boathouse. And there's a single-story boathouse as well. And nothing is changing on that frontage at all. So in terms of my analysis, as I noted, the district OP does allow for lot creation on Silver Lake, which it did not at one time. There is still a lake system health policies that do require an OPA and ZBA as well in this case. So the reports, supporting reports, water quality impact assessment, site evaluation report, I won't read what's there, but obviously the District of Muskoka is satisfied with the extent of the review that was done. Habitable buildings on the retained lot are to remain. As noted, there's actually 2 dwellings and a sleeping cabin, and they're to remain as non-complying structures. Again, they're distant from the water. There's no association with Lake Rosso from the farmhouse, for example, as well as these buildings are well away from Silver Lake as well. So, and the retained lot is a large lot, 62 acres, and the frontage is remaining the same. A number of severance options were considered. One of them, in fact, possibility was to actually take down the buildings that are on the property and build on the Silver Lake side and then sever off the Lake Rosso frontage. Not something that my clients want to do, but that was one way of looking at it. It would have reduced the environmental reports, that's for sure, but this is really the best way to go. The Planning Act criteria, I went through that in my evaluation. I won't go through that, but it's in my planning justification report. There's one comment staff made about the OS2 zone, and I know they're being consistent with what they've said in other cases. We would like the OS2 zone to remain as is, and that's because this was a working farm and still is to a degree, and the owners are considering in the future of getting into bees and honey production in a small way, and possibly chickens and maybe a greenhouse. So that's what they've indicated to me, and I believe the OS2 zone should stay, mostly because of history of the farm. In terms of timing, it did come up to me as to, why are we having this in February? I know it comes up from time to time. There has been some litigation, unfortunately, between the family members, and there's a court-imposed deadline. The court, in fact, had to give approval for these applications to be considered initially from the family side, and that did not happen until November. These applications were submitted on December the 10th, so we've gone as quick as we can, and we're here now in February. So that's why we're in the winter, unfortunately. So in terms of my conclusions, I believe that based on my report and the Beacon reports, it does make good planning sense, and it does conform to the official plans. And this is supported by, and I think I've gone through all of these things as well. So anyways, I'm hoping that committee will show some love regarding this particular application on Valentine's Day, and hope that you see your way to approval, and I'm here to answer any questions. Thank you.
Thank you. Anyone else here to speak in support of this application? Anyone who would like to speak against this application? Please come forward. Please give us your name and address.
Michael Ann McDonald Adams, 15 Joseph Street, Port Carling. I own Silver Creek as it comes from under the road and into Mirror Lake. Just built a new home there and living there with my husband. And I'm highly aware of the phosphorus sensitivity of Silver Lake because I'm the one that lives with the weeds that flow from it. And we've done water quality tests there for the last 10 years. So certainly that's been an issue. But I've also been involved with the Carr farm and the Carr family for 3 generations. And I am aware of the legal process, not involved because I'm in support of everybody on all sides, and so I'm conflicted. I can't oppose anybody. But in terms of the opposition that was stated in writing, if that person knew the whole story, the alternative to these severed lots is the whole of the Carr farm being sold. And if you think a developer isn't sitting waiting for that, you're all very mistaken. This is a way to preserve the Carr farm, which is, I believe, still a working farm. It's still, they produce a whole lot of really good maple syrup. And certainly the goal, I know Leslie's goal has always been to have greenhouses and get the farm well going again. So I support it wholeheartedly, and it's a way to preserve in this community one of the original founding families, which was the Carr family.
Thank you. Okay, that was support.
Yes, that was smart.
Yeah, yes, okay, great. Anyone else speak in support?
Paul Donaldson. And they didn't know I would speak. I didn't even know this was coming up, but I've walked that property on Silver Lake at least 5 or 6 times. And there's at least 3 building. The person who wrote the letter about the 5 lots, 5 lots wouldn't work there, but 3 lots would work there absolutely fine. I've developed many properties, walked a lot of land. There is a lot of tree cover along the shoreline. The property is deep. There's lots of place for septic in the back, and lakefront lots are hard to find, and there is no reason that there shouldn't be allowed in the future 3 lakeshore lots on that small lake. It's just the ideal place for somebody to have a reasonable price lot in and around Port Carling. So I think it's absolutely ideal.
Okay, thank you. We're only dealing, is it Mr. Donaldson? I believe the mayor would like to ask a question of you.
Thank you. Through you, Madam Chair. Paul, your question of your comment of walking the property for 3 lots, the proposal would be to actually create 2 lots presently. Are you talking about 3 lots on the severed lot or 3 in total? So there is 1,300 feet of rough
Having
frontage?
walked the 1,070 feet about 6 or 7 times. I haven't done it for a year, but I did it on behalf of the Carr brothers looking at it. As far as I'm concerned, you just have to walk it and you'd see that it would give lots of frontage, lots of acreage, and as far as I'm concerned, there's no reason why there couldn't be 3 lots on that 1,070 feet of frontage.
Okay, so that was the question, so.
Yeah, and you know what, they didn't pay me to come here, they didn't even know I would speak up.
Okay, so that's, and that's not before us right now, it's just the one. Councillor Jaglowitz?
Yes, through you, I have a question for the delegate also. So that's on the severed lot. How about the retained 301 feet? Is that suitable to
Excuse
severed?
me, Councillor, are you asking about 3 severed lots?
No, I'm asking about the 300 feet of the retained lot.
Oh, on Lake Rosso.
No, on the retained lot has a frontage on Lake Rosso, and it also has
Yeah,
a frontage on
but you know
Silver
what,
Lake.
it's not severable because the minimum frontage on Lake Rosso in a WR1 zone is 200 feet. So,
No, I'm referring to Silver Lake.
Excuse me, but I believe you're confused. There's 1,000 feet on Silver Lake,
yeah, and that's the severed land.
and
Yes.
that's what we are
It's
severing.
1,070
So,
feet on Silver Lake.
Councillor Jaglowitz, could you rephrase this and maybe I can direct it somewhere?
Sure, okay. The proposal is to sever off 1,080 feet on Silver Lake and retain 301 feet. I'm referring to the retained 301 feet. if in the future that was severed from the retained lot of 62 acres, would that be suitable, make a suitable building site?
Excuse me, but
Oh,
I don't
abs-
believe that's in front of us at this point in time to be answered.
And we should be addressing the applicant.
Yes, yes, and the staff, so, okay. Oh, any other questions? Anyone else to speak in support of this? Anyone in opposition? In support? Okay.
My name is Paul Doddington, and I own the adjacent lot to this property. We have been on a wonderful relationship basis with the Carr family. Our two families have known each other for well over 100 years, have been mutually supportive, and I would like to support this, but I would also like to point out that one of the major water resources, so we say, of Silver Lake is in the back land of this property. There's a huge amount of water that comes down from it. There's a kind of a ridge, if you like, that goes along in behind the shore of Silver Lake. Some of it's extremely precipitous, and I would hate to see the thing broken up into a lot of small lots. I think that would be a disaster there. In fact, many of us have sort of felt it would be a wonderful thing if it could become a parkland, particularly the very, very high part that's called Sunset Rock. In fact, a lot of the stone, which is in the little stone wall at the Anglican Church in Port Carling, was brought over from that in 1913. So it has a sort of a historic thing, but it's a cliff that is so steep that it actually goes underneath, if you know what I mean, like Niagara Falls. I think that we should avoid trying to build anything up there. It would be wonderful to keep it as is. Many people go there just to see the view. It's the best view on Silver Lake. You can see everything from up there. You can even see the Windermere House. So I think that it would be nice if that part were left in its natural state. It's one of the great beauty spots of Muskoka that very few people know about. But in behind is this, we call it the swamp, or the my daughter calls it the Bermuda Triangle. You can get lost in this wonderful swamp. Huge amounts of water come down in the winter or in the springtime from there, because it all comes into our property, so we know all about that. And I think that we have to be careful what we put there and as septic systems, because undoubtedly that would drain into the swamp. The swamp would, of course, mitigate everything, I suppose. But I think what I'm saying is that I think it would be okay to have one, possibly two cottages along there. I grew up wandering that property, and so did my kids. They love the place, and it is very, very beautiful there. And I think that we don't want to overdevelop it. I think that would be an important point that I would like to make. But I am in support of this because I'm supportive of the Carr family. I know they're in a bind here, and this seems to be about the nicest way of getting them out of that bind. Thank you very much.
Thank you. Anyone else care to speak in support? Anyone in opposition? Okay. Committee, anybody, any questions, any comments? Councillor Roberts?
Through you, Madam Chair, to planning and the district report asked us to defer.
Mr. Sharp?
Could you, yes, defer on this until?
Through you, Madam Chair. That was one of the recommendations. There are really two options. There is one to defer it for a wildland fire risk assessment, or alternatively to employ appropriate development control techniques. at the time that site-specific development plans are submitted, in order to ensure that that study is undertaken and that the development is appropriately situated within the large envelope that's been identified. So for single lot creation such as this, that's typically how we've approached it, is not requiring that specific study to be undertaken until the site plan control process is triggered by the development of the lot.
Would you like to speak again, Mr. Farmer?
Yeah, thank you for the opportunity to comment on that. I agree with staff. I think that that seems to be the modus operandi in the township for the most part in dealing with wildland fire assessments and concerns is site plan control, and my clients have no objection to that. That will happen, of course, at the time of building permit application, where you know more details about the actual proposal. So we would appreciate it if we could carry on and deal with that at site plan stage. Thank you.
Okay, thank you. So I believe that our motion covers that it'll be done under site plan agreement. If everybody's ready, I will read the motion. Councillor Jaglowitz?
Yes, I wonder if you'd allow me to ask the question that I inappropriately, I guess, asked the last time, so I'll ask it of staff. As I understand the proposal, there, it is the severed lot is to have about 1,080 feet on Silver Lake. The retained lot has a frontage on Lake Rosso, but also has a 301-foot frontage retained on Silver Lake. If after this severance is completed, an application was made to sever off that 300 feet with an appropriate acreage behind it, would that meet the requirements to allow that to occur?
Mr. Sharp?
Through you, Madam Chair, I would direct your attention to the screen, and I'll just point out the portion of the lot which I believe is in question. It's this frontage here, 301 feet. It's a portion of the retained lot that also has frontage on Lake Rosso. Minimum lot frontage and area requirements are based on constraints, specifically the steepness of slope or narrow water body. So there is no narrow water body constraints in this instance, but there certainly are some steep slopes. So it would be a question of whether this lot here would be appropriately zoned waterfront residential WR5 or waterfront residential WR6. The former requires a minimum lot frontage of 300 feet. The latter requires a minimum lot frontage of 400 feet. So, you know, in my analysis, there's certainly some potential that this portion could be appropriately zoned WR5, but we'd really need to see, I think, some more details with respect to the slopes. There's also a snowmobile trail that's been long established, so that would need to be considered as well as part of any future severance. I'm not sure what the Ontario Federation of Snowmobile Clubs comments would be with respect to the rerouting or the loss of that snowmobile trail. So that'd be something that would need to be considered as well.
Okay. Mayor Harding?
Thank you, and I'm certainly in support of this, and I appreciate the Carr's dilemma in trying to manage the way forward. I'm quite familiar with all aspects from Silver Lake to Lake Rosso of this property. I think ultimately in the future that 300-foot lot on Silver Lake could be severed and developed. It's actually one of the nicest, flattest little piece of property. I'm pretty sure it's a permission granted by the Carrs to allow the snowmobile trail to run through their property. To the sort of south or east of there, right now we've actually had a snowmobile trail closed because the property owner said no, and we're trying to reroute that trail as we speak. My only concern would be that of a development overall on Silver Lake, and I guess I don't have a problem with the 300-foot lot. I would be concerned about 4 lots, or maybe even 3 lots on the retained lot, and I appreciate Mr. Donaldson's comment that, you know, it is 3. Yes, it's very steep on a couple sides. I guess from a contemplation perspective, I would really like to look at a maximum future subdivision of that retained lot of just a couple. And I think that may help get to the finish line, but I'd just be worried about somebody coming in and saying 300 feet, and I think we could potentially contemplate that in this bylaw at this time, or maybe look to our Director of Planning, Mr. Sharp, if that's possible.
I think Mr. Sharp would like to chime in here. Thank you. Mayor Harding, you good with that?
No, I think that's fine. As long as, that development envelope is said, then theoretically, there really is only a maximum of 2 lots that ever could be developed, and I think we're okay.
Okay. Oh. Yes, Director Payne?
Maybe just to quickly add, thank you, Madam Chair. I think one of your requests was that it, just to note, the draft bylaw that's before you also would recognize the proposed frontage and acreage. So as much as there may be no policy basis to prevent future lot creation, any future lot creation of the severed lot will require a zoning application in front of council in the future, so.
Okay. Oh, Councillor Edwards?
I just want to say that right now, we're just looking at a severance on a lot, and that's all we're looking at. What ifs don't, and that don't come into play. I can support this the way it's laid out.
Okay, I'm going to read the motion. Moved by Councillor Edwards, seconded by Councillor Roberts. Be it resolved that Planning Committee recommend to Township Council the consent application B/52/19/ML, Carr roll number 5-7-047 be approved with the following conditions. That a registerable description of the severed lot along with any required right-of-way be submitted to the Secretary Treasurer along with a registered copy of the reference plan. 2, that a consent agreement with the Township under Section 5126 of the Planning Act be entered into wherein the owner of the severed lot agrees to implement in all respects the recommendations of the scope site evaluation report and water quality impact assessment prepared by Beacon Environmental and dated December 2019. This agreement is to be registered on title. 3, that cash in lieu of parkland be dedicated to the township in the amount of 5% of the assessed value of the severed lot or the entire lands, whichever is less. 4, that a zoning bylaw amendment be approved to permit the severed lot to be created. 5, the zoning bylaw amendment be approved to restrict building and structure locations on the severed lot. And 6, that official plan amendment 53 be adopted by Township Council and approved by the District Municipality of Muskoka. Any discussion? Okay. Affirmative? Those voting for? Against? It carries. Okay. To what?
That was the severance.
Oh, okay.
That's
Yeah, okay.
There's one for the official plan amendment, and then there's one for the zoning amendment. Okay, so they're all this.
Okay, thank you. Okay, so we need to do one here for the official plan amendment, and this is moved by Councillor Roberts, seconded by Councillor Edwards. Be it resolved, the Planning Committee recommend to Township Council that official plan amendment 53, Carr roll number 5-7-047 be adopted. Any comments? All in favor? Opposed? Carried. Okay, and then our, this is for the bylaw, be moved by Councillor Edwards, seconded by Councillor Roberts. Be it resolved that Planning Committee recommend to Township Council that ZBA-48/19, bylaw 2019-164, Carr roll number 5-7-047 be approved. Any comments? 4?
I was going to say, you have to ask the question.
I know, I'm sitting here going yes, against. Okay, that carries. But just anticipation, Ruth.
It's kind of like, and the winner is?
Exactly. Okay. Okay. Thank you. All right, so next on the agenda, and again, I believe it's with you, Mr. Sharp. Please take it away.
Thank you, Chair Bridgman. The next application to be heard is zoning bylaw amendment application ZBA-44/19 in the name of Donaldson. The subject property is known municipally as 1053 Brackenrig Road, Unit Number 6. I would direct committee's attention to the submitted site plans, drawings, and draft bylaw beginning on page 192 of the agenda package. The purpose and effect of the application is summarized as follows. The subject property presently contains a dwelling, a two-story boathouse with a sleeping cabin above and an associated dock. The applicant proposes to remove the existing two-story boathouse and dock and construct a new two-story boathouse and dock. The purpose of bylaw 2019-152 is to provide an exemption from the minimum required lot frontage of 300 feet on a Category 1 lake, being Lake Rosso, for a two-story boathouse. The applicant proposes to construct a new two-story boathouse in a different location, size, and configuration on a lot with 166.5 feet of lot frontage. The existing two-story boathouse will be removed. The purpose of the bylaw is also to provide an exemption from shoreline structure requirements, including the maximum height, the minimum side yard setbacks, the maximum second story length, and the maximum habitable floor area on the second story of a two-story boathouse. The applicant proposes to include the standard height, side yard setback, second story length, and habitable floor area requirements for a two-story boathouse for a lot with less than 300 feet of frontage on a Category 1 lake. The purpose of bylaw 2019-152 is also to provide an exemption from the maximum permitted cumulative dock width on a Category 1 lake of 25% of the lot frontage, up to a maximum of 75 feet. The applicant proposes to construct a dock with a cumulative width of 46 feet, or 27.6% of the straight line frontage. The purpose of the bylaw is also to provide an exemption from the maximum permitted cumulative first-story boathouse width on a Category 1 lake of 16% of the lot frontage, up to a maximum of 75 feet. The applicant proposes to construct a two-story boathouse with a lot, to construct a two-story boathouse with a first-story boathouse width of 32 feet, or 19.2%. The purpose of this bylaw is also to provide an exemption to provide from the maximum permitted cumulative second-story boathouse width on a Category 1 lake of 13% of the lot frontage, up to a maximum of 75 feet. The applicant proposes to construct a two-story boathouse with a second-story boathouse width of 25.5 feet, or 15.3%. The purpose of this bylaw is also to provide an exemption to the minimum required side yard setback of 15 feet. The applicant proposes to increase the minimum side yard setback to 30 feet for lands located within 200 feet from the high water mark from both side lot lines. The purpose of the bylaw is also to rezone a portion of the subject lands from waterfront residential WR1 to environmental protection EP1. The applicant proposes to rezone the wetland feature located toward the rear of the lot from WR1 to EP1. In summary, bylaw 2019-152 will have the effect of permitting a two-story boathouse on a lot with less than 300 feet of frontage, of including the building and lot requirements for a two-story boathouse, of permitting a cumulative dock width of 46 feet, of permitting a cumulative first-story boathouse width of 32 feet, of permitting a second-story boathouse width of 25.5 feet, of increasing the minimum side yard setback within 200 feet from the high water mark to 30 feet, and of rezoning a portion of the lot from waterfront residential WR1 to environmental protection EP1. Notice of this public hearing under the Planning Act was circulated 24 days in advance, and 6 submissions have been received to date. The first submission is by the District Municipality of Muskoka Planning and Economic Development Department. The department has no objections and requests to be notified of Committee and Council's decisions, and that is signed by Cassidy Fior, District Planner. The second submission is by Neil Donald, the Township's Chief Building Official, and the Development Services Department has no Ontario Building Code objections. Third submission is by Ken Becking, the Township's Director of Public Works, and the Public Works Department has no objections. The fourth submission is by Douglas Holland, the Township's Fire Prevention Officer and Emergency Management Coordinator, and the Emergency Services Department has no objections. The fifth submission is by Lynn and Steve Harper, who are immediate neighbors to the west, and the submission is as follows. This letter is to state how delighted we are for the proposed new design of Paul Donaldson's new boathouse. The current boathouse is a bit of an eyesore. Redirecting the direction of the boathouse would actually help us in parking our boats inside our boathouse, plus added distance apart for some privacy. By allowing Paul to change the design/look, it will only beautify the look from the water. Having similar designs just adds that wow factor. And again, that's by Lynn and Steve Harper. The sixth submission is by Sherry Daly, who is an immediate neighbor to the east, and the submission is as follows. Paul Donaldson has been very considerate, already informing us of his plans and discussing our concerns. I appreciate that he would like to rebuild the existing boathouse so that it is more pleasing in appearance and offers a view of the lake rather than being angled as it is now. Our own cottage was built by Mr. Donaldson, so I am aware of the quality of his work and his designs. In general, we have said that the current design seems to achieve his goals, as well as taking into account our possible concerns. I would still like to share my own view of the proposal and provide comments as an affected neighbor. The planners have done a good assessment based on all the rules that are in place. I agree with the planner's assessment and comments in Section C, shoreline structure width requirements, where they express some concern about the appearance of built form based on size. They point out that compared with the current boathouse, the proposed boathouse would have a first-story floor area over 2 times the size of the current boathouse. Visually, the proposed dock will be substantially larger than the current boathouse, although the planner's concern is mostly with the width. From our perspective, the boathouse will also appear longer and nearer to us. It will be a shift from a wide-angled position to a 90-degree angle to the shore. There will also be more activity closer to our waterfront area. When we moved into our cottage, our neighbors had one power boat that left from the front of the boathouse, which was angled away from us. The boathouse side that faces us is a narrow side where little activity occurs. We had a wide open area to swim and where we play with our dogs. With the new proposal, there will be 3 boat ports facing us, and I expect there will be more traffic and turning boats in an area that was formerly quiet. Although it has not been a main issue for the planners, I would like to point out that since 2014, properties have had to have 300 feet of frontage to qualify for a 2-story boathouse. This property has 166.6 feet of frontage, but because it has a 2-story boathouse, the owner will be allowed to build another one. I would ask the Planning Committee to consider the cumulative effect of all these amendments being requested by the applicant to determine if that is how they wish to see the development proceed. My own property has 183 feet of frontage, but no 2-story boathouse. As you can see from the photos in the planning report, our boathouse has a very low profile and mass. So although in principle I am supportive of Paul Donaldson's application to rebuild his 2-story boathouse perpendicular to the shoreline, I would appreciate if the Planning Committee would limit the mass of the structure somewhat. I would ask the committee to require it to meet rather than exceed the limits for dock width and boathouse width, first and second stories. I would ask the committee to also consider restricting the total area of the first floor, which exceeds what would be allowed as of right by 142 square feet, and which exceeds the previous boathouse first floor by about 840.6 square feet. This information is all found in the planner's report on page 13 and also in the chart on page 2. And they thank committee for the opportunity to comment, and they've requested notice of committee and council's decisions. Staff have prepared a detailed report for committee's consideration. Since our report was prepared, the applicant has correctly identified that staff's analysis of boathouse size did not include first-story portions that could otherwise extend 10 feet onto shore as of right. With permitted 10-foot extensions included, the proposed first-story portion is actually 188 square feet smaller than what could otherwise be constructed on the property as of right. Excluding a 2-foot sundeck overhang, the proposed first-story portion measures 1,408 square feet. Staff have no further comments at this time, and I'd be happy to answer any questions that committee may have. Thank you.
Thank you, Mr. Sharp. Would the owner or agent for the owner, Mr. Donaldson, please come forward?
Paul Donaldson, 3687 Highway 118, Port Carling. And as you can see, I was sitting beside my neighbor who was the 6th person to make a comment. But I think it's really important here to understand, and Bryce, if you would show the picture of what the existing boathouse is and how I could reconstruct it, I would appreciate that, because that's really important. That's the existing, but where is the one that I gave you that showed what I could build? Okay, so what I'd like to understand here is that we have an existing boathouse right here, and the fellow who knows originally John Reimer, he goes on the existing trips, and so the way the bylaw is written, you can build your boathouse. One side of the dock has to be a 90-degree angle to the shoreline, and so.
Excuse me, Mr. Donaldson. Sorry, I hate to interrupt you. We're webcasting and they can't hear you otherwise, so we have a little pointer for you, if you wouldn't mind.
How do I do that?
Oh, we have lots of help here.
Sorry, I'm a little bit technically illiterate.
Or you could walk with the microphone. You can take the microphone over.
Okay,
We're just
well,
trying
what
to
I'd like to
accommodate.
say is that when you come in from, like Mr. Harper says, I mean, I sold the house to Harper's next door. I designed the house that the Dailies are in and the boathouse on the next door property. So I know this boathouse very well. It is an absolute eyesore on the property. You come down Lake Rosso and this boathouse sticks out in front of you. Its width, as it is right now, the lower story of the boathouse, it looks to be 44'9". And the upper story, as it looks right now, looks to be 38'6". I'm proposing, instead of it looking like it's 38'6" on the upper floor, I'm proposing it to be 25'5". I'm proposing the lower boathouse to be 32 foot wide. As it looks right now from out in the shore, it's 44'9" wide. And the dock is 50'2" wide, and I'm proposing 46. But as my rights are to reconstruct this boathouse and leave the second story portion exactly where it is, okay, the boathouse, the lower story of the boathouse would become 62'7" wide instead of the 32 I'm proposing. The upper story would stay the same at 30.6 feet wide instead of the 25.5 I'm proposing. And the docks would cover 103.5% of the shoreline instead of the 46 that I'm proposing, by turning the boathouse perpendicular to look out at the lake. And if Bryce goes back to the original picture that shows the three properties together, if you don't mind, Bryce. Okay, so there was my original house to the left, and there's my, okay, sorry. There's my original house to the left. These are all survey drawings, and it shows the flat roof boathouse that I had up to the left. This is my neighbors over to the right, their cottage, and their boathouse. And what I've done is I've put that boathouse right kind of in the center of the property. The existing bylaw for 300-foot frontage and two-story boathouses is 45 feet from the property line. These docks are going to be 55 feet from the neighbor's property line, and the boathouse will be 57 feet. So all in all, as a built form from the lake, this boathouse will have half the size of what I could build if I'm forced to reconstruct it in the same place that it is right now, just because of the angle that it's on and the way the bylaw is written. So the other thing I've done for the neighbors, to their benefit, I've offered this up, is because it's these are very small lots, but these were very expensive houses, and they sold for a lot of money. So to protect the value of my neighbors on both sides, in case something happened to me and this property was ever sold, instead of the 15-foot setback that you would typically have on a property for dwellings, I've suggested to the neighbors, and I have done this on my own accord, that I put 30-foot, changed the bylaw on this property so that there would be a 30-foot setback.
So, Mr. Donaldson, if I could, it's technically 5 minutes, so I'm going to help you along a little bit here. We're talking about the boathouse
Yeah,
only?
but we are talking about the boathouse, but we're also talking, there's a provision in there to change the bylaw, change the property side yard.
Oh, just for that.
Okay, so, yes, so that the dwelling would be centered and create privacy for the neighbors, rather than me jamming it up 15 feet from the lot line on either side. I've changed it to 30 feet. And then in the back, Bryce asked me if, when we were looked at it, if I would change the backland to EP, and so that's part of what we've done. But overall, this will be a huge, hugely better looking structure, and less, what's the word you use all the time? Less obtrusive on the shoreline. Even this, compared to what is there right now, let alone how I could reconstruct it to make it substantially bigger. In fact, the way it works out right now, in the reconstruction, I can bring the dock over to 30 feet, to the 30-foot line of the property setback. And I'm 55 feet away. So I've tried my best to work with the neighbors. I've communicated all the way along through the whole process. So anyway, that's my submission. Thank you.
Okay, thank you. Would anyone else like to speak in support of this? Just your name and address,
My
please.
name is Sherry Daly. I live in Toronto, 17 Pine Crescent, but my cottage address is 1053 Brackenrig Road, number 4. So I did submit a letter and gave most of my points there. There's a lot of numbers being thrown around, and I'm going to ignore those because you know them already. Paul has been very good about telling us what he's planning to do, and I don't think we're actually arguing, Paul, that we don't want you to change it to a straight perpendicular to the shoreline boathouse. We're okay with that. And my husband's okay with everything because he just figures people should be allowed to do what they want to do within reason. I just would like you to consider, though, that Paul is sort of suggesting that if he doesn't get this option, he could make it a very long boathouse, the direction that it's already going. I don't think the other neighbor would be very appreciative of that because he's actually quite a bit closer to them with the angle. And if it was made longer, because that neighbor has to access their boathouse from the side, like Paul's proposing here, they really couldn't get in and out. My former neighbor, the Reimers, who owned the property that Paul has now, found it quite awkward when people were trying to park their boat in the former Donaldson property, the one to the west, I believe. And there was a bit of an issue there. So any dock that went further that way would be a big problem. I don't find the boathouse that offensive. It's an old boathouse. It's a single slip. It's going to now have 3 slips facing me. I understand that Paul has that many vehicles that he wants to park there, and he built our boathouse, which also has that many slips, but we do enter from the front. So I'm not really asking him to change his design, but when he's telling you that it's not going to be that offensive and it's going to not be as noticeable from the lake, it's still going to be much bigger than it was, and it's still going to house 3 boats. It's going to have a bigger floor area. It's going to have a bigger upper floor. It will look prettier. It will look consistent with the other ones. So just consider, again, as he said, these lots were originally 166 feet of frontage. The current rules are 300 to get a 2-story boathouse, but because this property had one, he's allowed to build a 2-story boathouse. I've just had experience in the past that I'm drawing on because we also owned a property on Little Lake Joe, and we had a frontage of about 188 feet, and we were turned down for a 1.5-story boathouse back when the limit was 200. So I'm just, I know you've changed those rules for a reason. This is a grandfather kind of situation where the applicant is allowed a 2-story, so I'm not arguing against that. Just consider the size and mass as your planners have suggested, and I know Paul's been very good about trying to accommodate and to and we actually do have a fair bit of room between the 2 boathouses, so I'm not arguing that we don't. But compared to what it was like when we purchased, this will be more, it will affect us more. And Paul is saying that, it's just going to be him, and it's going to be, he plans to live there, and but you never know what happens in future. So I'm just going with what is shown there and the assumption that there will be more activity closer to my property. Thank you.
Thank you. I'm actually not sure if that was for or against, but it was both. Yeah. Okay. Anyone else? I'm going to let I'm going to let everybody speak, and then you will certainly have a chance at the end to wrap it up. Anybody else in support of this application? Anybody opposed who would like to speak? Well, then you are up again, Mr. Donaldson.
So, I'd just like to point out, I think what needs to be realized is that right now, I've shrunken the boathouse down to 44 foot deep. And if I'm forced to go with a narrower boathouse where I can't have, if I was forced to come in from the front, then I would have a narrower boathouse. But what my opponent doesn't realize is that as soon as I go to a narrow boathouse, I can actually go 50 feet out with my structure out into the lake. So she'd be looking at a 50-foot wall instead of a 40-foot wall. She's also suggesting that my upper story is too big. I have made it square. So it's 25'5" wide facing the lake and 25 feet wide facing her. If I'm forced to cut down to 21.5 feet wide on the upper story, I will have to go deeper. So she will see a 32-foot wall on the side. The existing boathouse that's there now has a 704 square foot second story in it. I am shrinking that down to under 650 square feet. So these things about me building a bigger structure here is not true. I've actually shrunk the structure compared to what my rights are and compared to what it looks like. The other thing is, if I was forced to rebuild it the way it was, the swim dock, I would not put the swim dock towards the neighbors. I would put the swim dock towards these neighbors over here instead. But I put my swim dock out into the main part of the lake to give privacy. The other thing, if you can realize, there's 141 feet between the neighbor's dock and my dock, and that's to the corner. 141 feet, like, you have setbacks for two-story boathouses of 45 feet. So if you had two-story boathouses on two 300-foot lots, you'd have 90 feet between them. There's an additional 50 feet there. I've also offered in an email that I'm willing to put orange buoys or white buoys out in the projection of the property line. 55 feet is lots of room to bring boats in and maneuver and not go in front of the neighbor's property. Okay. So I just want to point those things out, that the built form is actually a way smaller than it is now, and what I can do in the future. Thank you.
Okay, thank you. Committee, any comments, questions? Mayor Harding?
Thank you, and I appreciate the neighbors' concerns. And the reality is, we have a lot of legal non-conforming structures that have development rights, and in totality, I have to say, I agree with Mr. Donaldson. What we provide them with rights today would be more aggressive to the neighbor and egregious to the neighbors and the area, because it is much more of a mass on the waterfront. And I appreciate that at times a boat may come somewhat in front of your property, I guess, depending where you are. I have 4 properties that are regularly 5 feet in the front of my dock to access their properties, just the nature of where my place is. So I have to say, I think I have to support this. There's a little bit of extra dock width, but based on what they have and trying to manage, I think it fits within the nature. If your boats were coming in that way and I could see 2 boats colliding, I get it, but I think I'd have to be supportive of this.
Thank you. Councillor Kelly?
Thank you, and through you, Madam Chair, obviously I don't have the opportunity to vote on this, but I do have a couple of observations. We on council, you on planning committee, have to deal with lots of pressure to develop and redevelop waterfront property. We know that. That's part of the job we took on. And there's no perfect application. So I think we got to look at applications that have some of the hallmarks of things we've seen today, both from the Carr side and also from the Donaldson application. Sensitive to the needs of the neighbors, sensitive to the environment, not necessarily building to the max that they might be allowed to, consultative with the neighbors, respectful of the neighbors' wishes, and I appreciate from the neighbor's perspective, it's not perfect, but I defy you to find one that is perfect. Probably the only perfect development is tearing down existing built structures and letting the thing to revert to nature. There's a lot to be applauded here. I think a lot to be supported here. And if every application that we have to deal with, either a planning committee or council, comes with this kind of thought and a similar approach perhaps to what we saw with Carr, I think our lives would be a lot easier. Thank you.
Councillor Edwards?
And that, just a comment, I will support this because it's better than what was there.
Anyone else? All right, I am going to read the motion then. Moved by Councillor Edwards, seconded by Councillor Roberts. Be it resolved that Planning Committee recommend to Township Council that ZBA-44/19, bylaw 2019-152, Donaldson Roll number 2-8-007 be approved. Any comments? Those in favor? Opposed? Carried. Okay, thank you. We're going to take a 10-minute break now. We'll be back at 25 to 11. Thank you.
Which project is up next, just so I know? Cutting Brothers, or Ontario Inc. I'm 3 away. He's just informed me. Okay, so I guess it'll be after lunch then, I think. I don't think so. Okay. Good, then I'll hang around. Back after the break, the next two can go there. They don't all take an hour.
name of Prodan/Blockchain Real Estate. The property is presently in the ownership of Brian Prodan and Blockchain Real Estate, excuse me. The property has no civic address assigned at this time, but is located at the intersection of Josh's Bay Road and Skeleton Lake Road number 4. The purpose of this application is to rezone the subject lands from open space OS2 to rural RU1. The RU1 zone permits a range of uses, including agricultural uses, bed and breakfast, conservation, residential dwelling unit, farm, forestry operation, kennel, open space recreation, rooming house, wayside pit or quarry, and secondary dwelling unit and home-based business are permitted as accessory uses within that zone. The purpose of this application is also to recognize the existing lot area and the existing lot area of 3.17 acres to be considered the minimum required frontage. The RU1 zone requires a minimum of 10 acres of area, to be considered a building lot. The purpose of this bylaw will be to rezone the subject lands from OS2 to RU1 and recognizing the existing lot area to be the minimum lot area requirement. We have received a few pieces of correspondence related to this application. The first from the District of Muskoka. The District of Muskoka has no objection. We have received comments of no objection from the Township Public Works Department and Development Services Department. We also have received comments or concerns from a neighboring property owner. Their concerns specifically are related to increased density in the rural area, landlocked renters continuing to walk onto private property in search for swimming and hiking opportunities, and noise from potential renters. That's from Tyler Grace, and he wishes to be notified of council and committee's decision when appropriate. Staff have prepared a detailed report, including photos of the subject property. Happy to answer any questions.
Thank you. Is the applicant here or agent for the applicant? Please come forward. Name, address, and...
My name is Frank Adachi. I'm the owner of Blockchain Real Estate, and this is Brian Prodan, and we purchased the property together. So basically, just to explain what is happening, I noticed when we were purchasing the property that everybody that is south of that road allowance, where the north part of our property is, everyone who's south of there is labeled as residential, and our space is the only space that's labeled as open space. We weren't sure why that was, so that's why we're here today with our application. Brian Prodan plans on living there personally, and we're going to build a house, and he's going to send his daughter to the nearby school. Yeah.
Okay, would you like to speak or not?
No, it's okay.
Okay. All right, so there may be questions after. At this point, is there anyone else that would like to speak in support of this application? Is there anyone, you could sit down for now if you like, if there's anyone who would like to speak in opposition to this application? Okay, so then committee members, any comments? Councillor Nishikawa?
Thank you. Ryan, through you to Ryan. Would it be appropriate at this time to eliminate some of the permitted uses under this zone? Are we able to do that?
Mr. Sharp?
Through you, the planning committee can recommend anything to council if it's the will of the committee to reduce the range of permitted uses. That could be included in your recommendation to council.
Yes, please do.
I would like to address, just listening to the concerns of the letter that was written and assuming some other things from that, you know, concerns about trespassing and that type of thing. I would like to put forward to, or for discussion with the applicant, to remove the forestry operation, the kennel, the rooming house, the pit and quarry.
Okay, would the applicant like to respond to that? Let's see what you think.
Yes, is this in concern with the letter that was written by the neighbor?
And my also experience generally with neighboring properties.
Okay, from what I understand, as far as what the neighbor's concern was, because I thought that's what you had mentioned at the beginning, in regards to looking for a route to the water, there is a road that goes right to the water. So there would be no trespassing if that was the case that, in that situation. But yeah, I don't understand why you're talking about the quarry and I don't think that's...
There are certain uses that come with this zoning, and what Councillor Nishikawa is asking you is, would you be willing to have those
removed,
eliminated from your property? I believe that's what she's asking.
Yeah, I suppose we could. There was no plan to have those. It's just as you remove things, you take away from the ability to do things on the property. As far as what we wanted to do, we wanted to make an application to maybe cut some of the rock out to build some of the house inside the rock. I don't know if that was a possibility. We didn't have any time to look into things like that just yet. I don't know how that would affect those situations if we did remove those conditions.
What I had heard was that you wanted a residential site.
That's exactly what we're looking for.
But again, with that, it comes with so much broader things. Going from an open space to a residential site where people would assume that they were just going to have a home on a property and a neighbor. The concerns that I brought forward were basically to eliminate any further, so operating a pit and quarry.
Right, that's no intention of
Right,
ours.
so let's, if you don't mind, let's,
Yeah.
take that off the list. The rooming house,
No intention.
right. And as I said, forestry and the kennel.
A camp?
A kennel, like to have a dog kennel.
No intention.
Right, so
Fair enough.
if we could move forward with that,
Yeah.
I don't have any problem with this application.
Those three items don't appear to me.
Four.
What's the fourth?
It's four.
Sorry, there's four. There's the rooming house,
Mm-hmm.
the pit, the quarry, the kennel, and the forestry.
Operations.
Right.
Would a pit include the inability to cut out some of the rock?
No.
Would that affect our ability?
No, that's a site plan discussion with.
I
It would be
see.
a commercial, it would be a commercial, like a, sort of like a commercial operation?
Right. Fair enough.
Okay. So are you,
Ryan was going to speak, so.
Mr. Sharp?
Thank you. I just wanted to provide a bit of clarification. The permitted use is wayside pit or quarry, and wayside pit or quarry is defined in the zoning bylaw as specifically being related to construction of road by a municipality. So it wouldn't permit somebody to operate a private quarry on their property. It would be a temporary quarry related to roadside construction undertaken by a public authority. But that being said,
Sometimes
it could easily
fogs
be
things,
removed
yes.
from the list of permitted uses.
Mayor Harding?
Thank you. Question to, I guess, Mr. Allen, and you can have a seat, it's okay, I think we're probably good with yourself. Applicant suggested that they're sort of residential properties. Are they RU1 zones such to the south of that road allowance? So if the neighboring properties all typically RU1 zones?
All of the neighboring properties are RU1 zones with that range of permitted uses that were discussed.
So I will say, as much as I appreciate we don't want a rooming house, we have housing problems within our municipality. And we regularly say, where are we going to put people, what are we going to do, whatever. Heaven forbid, 5 years from now, the owner of this property said, I need to make some money, and you know what, I'd like to have some dogs and have a kennel, or heaven forbid, I'd like to have and set up a rooming house to be able to accommodate people under certain bylaws and everything else. And I appreciate you want to rezone it now. It seems like an oddball zoning on this property, and everything else is an RU1 zone. Again, the pit and quarry, it's not a pit and quarry. So if you want to remove your rights, that's fine. I don't need them removed for myself.
Mr. Pink?
Thank you, Madam Chair. Just one quick clarification. The zoning bylaw requires a minimum of 10 acres to allow a kennel. This is 3.2, so you can cross that one off the list of your debate.
Thank you. Councillor Roberts?
Thank you, Madam Chair. My question's been answered.
Anyone else have any questions? Councillor Jaglowitz?
Yes, through you to staff. Why was the property originally zoned OS in the first place?
Through you.
Mr. Allen?
It's a great question. I went back and had a look at the previous zone mapping. It seems to be an oversight on the part of the people that created the mapping, and the way that the open space zones are applied versus the rural zones is primarily based on road access, specifically frontage on a year-round maintained road. And Josh's Bay Road, up until this point, is a year-round maintained road. So this property should have been rezoned RU1 from the beginning, but was not. The road maintenance may have changed at one point, but today there is adequate frontage on a year-round maintained road.
Okay, any more comments? All right, so Councillor Nishikawa, are you still wishing us to consider?
I think that would be up to committee.
Yes, I'm going to, do I have an appetite for this? Considering restrictions on this property? No, all right. I'm going to read this the way it's written. Moved by Councillor Roberts, seconded by Councillor Edwards. Be it resolved, the Planning Committee recommend to Township Council that ZBA-47/19, Bylaw 2019-162, Proton Blockchain Real Estate Roll Number 2-21-104-03 be approved, subject to the removal or relocation of identified structures. Any comments? Any discussion? Those for? Opposed? Carries. No. Yeah. Yeah, okay. That carries. Yeah, okay. Okay, thank you. Okay, so we're on to our next one with, I believe it's the Hinks property, and again, Mr. Allen, that is to you.
Thank you. This next item is a public meeting for zoning bylaw 0120, bylaw 2020-08 in the name of Hinks. The lands are presently in the ownership of Melissa and Daryl Hinks and are known municipally as 1126 Skeleton Lake Road Number 2. In 2017, a temporary use zoning bylaw amendment was passed to permit a home-based business involving the repair, maintenance, and storage of watercraft within an attached garage for a period of up to 3 years, and that temporary use bylaw expires April 13th, 2020. The applicant proposes to extend the temporary use of the home-based business involving the repair, maintenance, or storage of watercraft within the attached garage for an additional 3 years. As part of that bylaw that was passed in 2017, there was an additional permission to grant a lot coverage of 13.8% related to the presence of a shipping container. That portion of the bylaw will continue to remain in effect if the temporary use bylaw is not extended. We have received comments from the District of Muskoka of no objection. We have received comments from the Township Public Works Department and Development Services Department of no objection. We have received a letter of support from Sandy Hardju, Nancy Hardju, and Paul Kent, who indicate that they are neighboring property owners, and these people, the Hinks, keep their property in great working order and well maintained. We have also received one letter of objection from Gino Dinola at 1120 Skeleton Lake Road Number 2, which is the immediate neighbor to the west. Gino notes that they are in favor of people making a living, but rights of airspace and property value need to be considered. They note that the repairs were to occur inside the garage, but they observe boats on frequent occasions being stored and maintained outside of the garage. Gino has tenants that live in the house next door, and it's not fair to have exhaust fumes 20 feet away from windows in a backyard deck. It's noted that they've put up with this use adjacent to them for 3 years already, and it sounds like it's going to be an additional 3-year extension again and again. There was an email and a phone call to Mr. Popple on October 9th, 2018 to advise him that Mr. Hinks was working on his boats in the driveway and also storing them in the backyard behind the garage. And there was pictures emailed. Gino notes that they had never heard back. This property is not zoned as a marina. Engines give off a lot of fumes. During the spring and fall seasons, when the boats are being moved and winterized, they are not supportive of this application, and there is also concerns about fire or gas explosion if something occurs in this garage related to the use, repair and maintenance of watercraft. Those are all of the submissions received. Staff have prepared a detailed report. Staff are supportive of the extension of the additional 3-year temporary use and would be happy to answer any questions you have.
Thank you, Mr. Allen. Is anyone here, the applicant or agent of the applicant, to speak on behalf? Please just give your name and address.
Daryl Hanks, 1126 Scouten Lake Road number 2. And I'm just reapplying to do the 3-year. Now, the reason that we went this route with the temporary zoning was because of my neighbors. I have, other than one particular neighbor who you've heard from, all my other neighbors are great people and I get along with them well. And the reason that I wanted to go with the temporary zoning is that if I sell this property and it's zoned commercial, Lord only knows what would move in there when I leave. Like, it would be open to Lord knows what, and I just don't want to do that to my neighbors that are good neighbors. There's been ongoing issues with Mr. Denola and myself in the past, and I understand his point of view, but I'm very conscious about his neighbors, their tenants. He actually has good tenants in there for the first time in a long time.
Excuse me, but can we stay focused here? We try to stay very respectful and on track. So
Yeah.
we have heard the complaints from your neighbor. I think only addressing some of those, that the boats were outside, that would be more appropriate.
I was never under any understanding that I was to work on boats only in the garage and not outside. Like, some boats just don't fit height-wise inside the garage, so I do some repairs in the driveway. But since the last time I was here, I have constructed a fence to block off the view so that they don't have to look at my boats or any of the stuff. So.
Okay. All right.
And one other thing that I'll add, and I added this last time, is that the Denolas don't live in that house. They basically use it as a storage facility, so,
Okay, so I think that, again,
yeah.
we'll just leave it at that. So unless you have anything more to add in terms of your working in business, we probably have questions here, I would guess, from the committee.
Okay.
In a minute, we're going to see if anybody else would like to speak in support of this application. Anyone opposed to this application? We're opposed? We're having a hard time today on opposed and for, I can tell. Okay. Would you like to speak? Sure. Okay, you may sit down. Please just give your name and address.
Yes, John Dotsko. I reside at 1160 Skelton Lake Road 2. I have been living there for 4 years. On numerous occasions, I've been by the residents in questions. I've never had any concerns about noise. There's never been any boats, equipment left on the roadway to cause any sort of restriction for traffic flow. I'm in favor of this bill to be passed. Thank you.
Okay, thank you. Anyone who is opposed to this? Okay, then I think I'll bring it back to committee. Any questions, committee? Councillor Nishikawa?
Sorry, Brian, is there outdoor storage permitted or has it been restricted to a certain amount?
Through you,
Mr. Allen.
outdoor storage is not permitted. There are presently 2 boats being stored to the rear of the existing garage. It's my understanding that those are Mr. Hank's personal boats. There's no limitation on storing personal effects on your property. There's a restriction in the zoning bylaw related to the outdoor storage related to a home-based business.
Anyone else have any questions? Councillor Edwards?
I have never had a complaint in the 3 years it's been operating, and I would support this. I think it's good rather than rezoning it, as Mr. Hinks said, so I would support it.
Thank you. Any other comments? Right, I'm going to read the resolution then. Moved by Councillor Roberts and seconded by Councillor Edwards, who appear to be doing all the moving and seconding today. Be it resolved, the Planning Committee recommend to Township Council the BZA-01/20 bylaw 2020-08 Hinks roll number 2/18/012 be approved. Any comments? All in favor? Opposed? That carries. Okay, thank you. All right, so we will now move on to our site plan section. So I believe, Mr. Allen, you are up again with 1425934, Ontario, Inc. And I believe, yep, never mind. And I believe Mr. Cutter wanted to... Cutting, I'm sorry.
That's okay.
I had to look at it again, so please come forward.
Yes.
Lawrence, if you don't mind, I'll introduce the application and then you have a chance to explain. A site plan agreement application, SPA 0119, in the name of 1425934 Ontario Inc., also known as the Cutting Brothers, at 3680 Muskoka Road 118 West in Port Carling, has submitted a proposal to construct a 3,600 square foot addition to an existing building to be used for custom woodworking and timber frame manufacturing. Just to give you a high-level review of the report, no changes to access are proposed. The property is currently not serviced with sewer or water, so we'll be using the existing private services on site. Pinestone Engineering has completed a stormwater management review and has recommended, other than erosion control measures during construction, no additional systems are required to be installed. There is a stormwater management pond on the adjacent lot. This lot was once connected to that lot prior to a severance, and that stormwater management pond has sufficient capacity to accommodate the additional flows generated by the proposed building. There are some elevations attached to your agenda package that show the building roof line slightly above the existing roof line, and it's my understanding that the building addition will be clad similarly to the existing building. I'm happy to answer any questions.
Thank you, Mr. Allen. So, Mr. Cutting, would you like to come forward and...
The purpose is for future expansion. We're experiencing a very high influx of work, especially manufacturing for outside the area as well as inside the Muskoka Lakes area. And I don't know how long, if the site plan agreement is approved, it's going to take me to actually make application for building yet. I've only been through this once, and I know it was a good experience for both Cutting Brothers and the council. We met all the requirements, and I can't think of any issues with it. But with the approval today, I'll probably go back to my office, talk to my partners, and talk about immediate construction. Not that it's going to happen right away, because there's some new equipment, exciting equipment we're thinking about purchasing based on getting this new square footage.
Okay, thank you. Is there anyone else who would like to speak on this? Okay, committee members, any comments? Questions, comments? All right, I'm going to read the resolution. Oh, sorry, Mayor Harding?
I guess the only question is, I think we're requesting this to go to site plan to register and title within 2021, or is that construction needs to be done by then? Just to confirm with Mr. Allen, if you're not ready to build by then.
The reference in staff's recommendation that this approval will expire March 11th, 2021. So the applicant needs to enter into a site plan agreement with the township prior to that date. They do not have to obtain building permits or start construction by that date, but the agreement needs to be entered into, or this, if approval is granted today or by council later, it will expire at that date.
Just a supplemental, if I may, and I guess probably to Mr. Cutting, are you okay with, you've got a year to kind of figure out exactly what you want to do and enter into site plan?
I would like to have the agreement and then probably go to permit at that point. I just have to find out about my finances to see what I have. I wouldn't be agreeable to being, I mean, we could go to another site plan agreement so I just need to understand, can you clarify what you just said?
Mr. Allen, we figured you.
Yeah, no, but I need to be clear on what he said before
Mr. Allen, please.
Thank you, through you. We have all of the required information in front of us today to approve and enter into an agreement with Mr. Cutting. Once the agreement is entered into, you have 2 years to obtain building permits and start construction.
Okay, that I'm agreeable to. That gives me lots of time.
But you don't have to do that agreement today. You have, right? You have a year before you even have to enter into the agreement. Am I not correct, Mr. Allen?
Correct.
And then 2 years after that for the permit. But I would be willing to enter into the agreement immediately, as long as you know.
That's fine. And that'll be at your option.
Yeah,
That'll be at your option.
2 years is plenty of time for me. Okay.
Everybody's happy.
Understand, right?
Yeah. Okay, I'm going to read the motion. Moved by Councillor Roberts, seconded by Councillor Edwards. Be it resolved, the Planning Committee recommend to Council that SPA-102/19-1425934, Ontario Inc., roll number 4-20-003-04, be approved subject to the following conditions: that satisfactory comments are received from the District Municipality of Muskoka and any requirements are implemented. This approval will expire on March 11th, 2021, unless the corresponding site plan agreement has been entered into and registered on title of the lands. So, any comments? Those for? Opposed? Carried.
So where do I sign?
It's
Anyways, get back.
Okay.
Thank you.
Okay, so where are we going now? Okay. Okay, we're going to head into unfinished business now, and I first would like to introduce our, from the district, we have our guest, Mr. Soya, who is a planner with the district and has been involved with the Mary Jane Lake application, so we thank you for being here. So I would like to just, because this has come back to our planning committee from council this last session. There was some question about perhaps there was some confusion, and council just asked that as the planning committee, we take another look at that, which is fine. We can do that. What I do want to do, because this is a little different than an initial application, is just let you know where we sit right now with this, so everybody understands that. So the Planning Committee in December, at the December meeting, we decided to defer our comments to the district because that's all we're being asked to do. It is the district that would be approving the subdivision plan. They're just asking for our comments at this point. So we decided to defer that as a committee, and at that point, we had asked that the applicant bring forward 2 new studies, one regarding the habitat of landing turtles, particularly in the overwintering, and the second one an environmental review of section B17 of the township's official plan. So that's where it sits now. We're back to talk about it, which is great. We may have more information. We may have time to think about it. What we're not going to do is revisit the whole presentation that we had in December. What we're looking for here is either clarification, if somebody thinks that there wasn't any, or new information that may impact our thinking. So I just wanted to sort of lay that out at this point, and then I'm going to invite Mr. Ross up to speak.
Thank you, Madam Chair. If I might.
Oh, certainly. Whoever you prefer.
Thank you, Madam Chair. I do have a short presentation that I have copies of. I would give one to Mr. Usher and distribute the rest to committee, council. I'd like to again thank the committee for
looking at this on our behalf again. We are requesting that the committee reconsider its resolution.
Excuse me, could I just have your name and address?
Oh, I'm sorry. It's, yes, Rick Hunter at Plantscape, 104 Kimberley Avenue in Bracebridge, P1L1Z8. Again, we're requesting that, the recommendations on proposed conditions of draft approval that were presented by staff at the last meeting in December be endorsed and forwarded to the district so that the district can make a decision on the application that's before it. It's our submission to you that the items that were requested in the December 13th resolution have already been addressed and that no additional study is required. Mr. Shaw will be speaking as well, but he's provided information on compliance with the species at risk protocols and confirms that no additional Blandings turtles research is required. Also, in my November 1st, 2019 response to the issues, I provided an extensive review of the extent to which the proposal satisfies the requirements of the official plan, particularly related to section B17, which is development on undeveloped lakes. If you refer to the report, it's on pages 4 to 7 of that particular report. I'd like to remind the committee the EIS has been prepared in full compliance with district and township requirements. It's been peer reviewed through the district and also reviewed by the Ministry of Natural Resources and Forestry. The process for preparation of that report, review by the ministry, and the peer review were set out with township and district staff at the beginning of the process, and these were adhered to in the processing of the applications. So I've noted we've worked closely with township and district staff to ensure that the development is appropriate, that it conforms to the official plans and satisfies the protocols for environmental review. I would note in reviewing section B17 again, there is no requirement for an EIS to address the provisions of that section. However, the EIS that was undertaken as a result of other requirements in the official plan for major development, because it's more than 3 lots, did identify natural features. Those natural features have been carried over into the zoning bylaw, and we now have an application or applications that are before committee that are very extensive, that identify natural areas, that protect those natural areas from development. Applies to, again, the wetland areas, their buffer areas, and the type 1 fish habitat. I would note that some of the information in reviewing the material that was before you, that all of the area with identified type 1 fish habitat is protected from development, and that accounts for well over 2,000 feet of shoreline that will be protected around the lake. Also, I had my staff identify or measure out the natural features and their buffers, and there's a minimum of about 4.3 hectares of land and over 1,900 feet of frontage in the immediate vicinity of Mary Jane Lake. That will be zoned environmental protection and will have no development on it and will be protecting all of those natural features. Again, we would request that the committee also hear from Mr. Soya, who I believe would comment on the protocols and the procedures that were undertaken. And I would just reiterate our request for a resolution to support draft approval to the district at this point so that we can move on with the next steps of implementing the proposal and the conditions. Thank you.
Madam Chair, Committee, thanks for having us again. Al Shaw, Riverstone Environmental, 47 Quebec Street in Bracebridge, P1L 285. Mr. Hunter did a good job there going through some of the stuff. A lot of it is environmental based, which was certainly where I was involved in the process. We did an EIS, followed the protocols, and as Mr. Hunter did point out, we sat down with staff to make sure that all the items that needed to be addressed were put into the terms of reference, and that we did those. The EIS was then peer reviewed. They had some comments. We did a little bit more work, satisfied those comments, came back with an addendum to the report, and then it went off to the M&R for peer review. A lot of the comments have been about species at risk, and I feel really strongly about this, that really the test for whether you've addressed the species at risk components of a development project it lies with the Endangered Species Act. And the Endangered Species Act at the time was administered by the Ministry of Natural Resources and Forestry. They were the ones that went through the review to determine that we did enough or didn't do enough work. The comment that came back from the M&R after wasn't, I've got the whole quote here, but basically that we did a good job, and that a good job in serving for and addressing concerns about species at risk, and they did not require any additional work, and it was their opinion that a permit wouldn't be required to move forward with the development. And that at the time, of course, was when it was a 14-lot development as opposed to the 10 that's present right now. And when the discussion went around about needing more studies on Blanding's turtle at the last meeting, I had my hand up in the back, but it really wasn't appropriate at the time for me to come back and speak, unfortunately, because I really would have liked to have pointed it out a little more strongly at that point, that really the test for species at risk has been met. The agency responsible has signed off, and the, you know, if these studies have to go forward, you know, it's fine. You know, I make more money, my business does more work, but at the same time, I really feel very strongly that the test, it lies with the Ministry of Natural Resources and with the Endangered Species Act, and they were complimentary of our work and signed off on it. If we go ahead and do more work, then what is the test we are trying to meet? Who is going to be the one then that says, okay, that's, now you're good, or now you've met the requirements of the Endangered Species Act? That's already been said. That's already been done. And if I could say, the biologist at the M&R that reviewed it is one that's known as a stickler. He dots the I's, crosses the T's. He's very conservative, and felt very good when I got that comment back from him that the work was done in a manner that he could stand behind as well. So I'm here to answer any other questions if anything comes up regarding species at risk or the environmental studies.
Thank you, Mr. Shaw.
Thank you very much.
Would anyone else like to speak on behalf of this? This is an agenda item, so certainly Mr. Ross, please come forward.
My brother Doug, good morning, Madam Chair and members of council, members of staff. Thank you for welcoming us today. My brother Doug has...
Your address.
My address is, my name is Drew Ross. My address is 1058 Carlingford Road, here in Muskoka. My brother Doug has circulated a letter that's been distributed this morning. If you would please refer to it. I'm happy to bullet and highlight some points if needed. I would like to reserve my time, Madam Chair, to speak following all who speak today, if that's possible. Thank you very much. Would you like me to take the opportunity then to just make mention of my brother's points and the letter that he sent?
If you can just
Right
summarize it, that'd be great.
I can do that. Okay. So we met in January 2017 with district staff and township staff for this very purpose, to ascertain processes for what prongs would be needed in an EIS, what prongs would be needed in terms of the species at risk piece. That was laid out, and I would encourage members of council, members of the planning committee to take advantage of staff members here today who attended that meeting. Those include Mr. Pink and Mr. Soya, and it was very clear that there would be a peer review. The firm would be selected by the government, our local government, and that peer review would occur. There would also be a protocol established for the species at risk piece, and that being the Province of Ontario Ministry of Natural Resources. Following the completion of the work would be submitted to the Ministry of Natural Resources for their review. That was the standard that was laid out by the township and the district in January of 2017. The Planning Act affords me and our family as applicants the opportunity to consult with staff of local governments for this very purpose. Okay, and so we followed it to a T. We circulated agendas prior to the meetings. Okay, and I would ask for corroboration from staff members if they feel so inclined. Following the meeting, there was a memorandum of agreement outlining exactly what would be required. And in all cases, as I'm told by staff, the Ministry of Natural Resources does hold the review of the species at risk piece. And of course that's natural because, let's face it, any consultants I would hire are biased. They work for the applicant.
Similarly, any consultants hired by an opponent work for the opponent, okay? And the purpose of the peer review is the unbiased nature. The purpose of the Ministry of Natural Resources handling the review of the species at risk piece, well, first of all, the Endangered Species Act is in the realm of the province, and it's a government act. And secondly, most certainly, the Ministry of Natural Resources is perceived to be the most unbiased tribunal we would have on this piece, as well as possibly the most knowledgeable, certainly a representative of the public. That's the essence of my brother's letter as well, making note that he requests today that Township of Muskoka Lakes Council, through the Planning Committee, agree to make comment on our application that sits with the district. The township has been asked for comment, and we request comment. We would like our application to be heard by the district. Thank you very much. I'll speak my presentation following all.
Thank you, Mr. Ross. Anyone else care to speak in support of this? I know, Mr. Usher, anyone who has a differing opinion. Mr. Usher, would you like to come forward?
Thank you, Chair Bridgman and committee. I'm Tony Usher, 63 Deloraine Avenue, Toronto, M5M2A8, and I'm here again today on behalf of Lisa Grogan-Green and John Brave. And as best I understand, Council's decision to send this back here for further review was in response to Mr. Drew Ross's letter of January 8. I take it the letter, there's another letter that was Mr. Ross referring to that letter or to a newer letter?
We received a letter today from Mr. Ross's brother.
Thank you.
That's what he was summarizing.
Thank you very much. So I carefully reviewed the January 8 letter, which, because I haven't seen the new one, against what was put before you and the almost 2 hours of discussion that followed on December 13. And there's no information from my reading in that letter that you didn't have at the December meeting. Mr. Ross simply would like you to reconsider your decision to require 2 additional studies that I recommended, and I'm still hearing that message today. He says in the January 8 letter that if he'd been allowed to speak when you were finalizing your decision, you would have made a different decision. Well, Mr. Ross had already addressed you for 15 minutes at that point, not counting his answers to your questions, so I'm not sure what he was holding back that would have changed your minds. But since that's where we're at, is where we are now, I'm here to ask you to stick with your decision to require the 2 studies, and I'd also like you to reconsider your decision not to require the 3rd study I recommended, which was the boat impact assessment. And I want to emphasize again that Mary Jane deserves very special scrutiny. Only a small minority of the Category 3 lakes in this municipality are undeveloped, and Mary Jane is unique even within that select group. We heard in December from the applicant's team about non-relevant development on other lakes, like Cane and Thorn Lakes, which are Category 2 lakes and developed, and bushes on Barrett Lake, which is a totally different situation. In December, you asked as a committee for a review of the proposal against the natural environment components of the OP's undeveloped lakes policies. This is a desktop exercise and would not be a significant time or cost burden. You also asked for a eDNA testing to determine whether Mary Jane provides winter habitat for Blanding's turtle. And biologist Sarah Mainguy recommended this because there are more Blanding's occurrences around the Ross property than the applicant's team was aware of when they did their work. On this, we do have new information, which is in Ms. Mainguy's recent letter that was circulated to you, and the map with that letter, and which confirms yet another occurrence along Carlingford Road. And this latest occurrence further confirms Ms. Mainguy's opinion and conclusion that Blandings may be widely dispersed across the Ross property. And the purpose of the eDNA testing is better protection and better development, which should be complementary, not conflicting goals. Now, you did not ask for a boat impact assessment in December. And that term, boat impact assessment, comes from the official plan, and I used it because it's your hook to require it from an applicant. But we're used to boat impact assessments that basically count the existing boat traffic, estimate future traffic, and make some safety recommendations. Mary Jane Lake requires something quite different than that, so maybe my calling it a boat impact assessment was confusing, and I'd like to clarify that. The OP gives you great flexibility to scope a boat impact assessment to what the situation demands, and here is what I think is actually needed. First, assessment of the applicant's boating management proposals against conventional water surface recreation standards, including that only half the lake's surface is actually usable for high-powered boating. Second, assessing the boating proposals against environmental considerations, especially possible disturbance of the lake bottom, it's very shallow, and the shoreline habitats. And this would also take into account any relevant results of the two other studies. Third, any necessary modification of the boating proposals to reflect those things, and possibly also lot layout as these findings dictate. And fourth, the important bottom line, translating the boating proposals as modified into a regulatory framework that will bind all future owners. Mr. Ross said at the December meeting, quote, "What I'm proposing is a mechanism by which we can best enforce the circumstance that is intended and designed." He also said that their investigations and consultations with experts have, quote, "resulted in the road association access easement as the best and most viable solution for enforcement." Two problems. First, nothing in the proposed approval requires any of this. It's all left up to the present and future owners. And second, the expert opinion that was put to council was only the applicant's consultant saying, "Here's our client's boating plan. We believe all the owners will buy into it, so it's good." I said in December that implementing the Ross's good ideas will depend entirely on the goodwill of present and future lot owners. Without any regulatory framework, it will take only one cooperative owner to wreck it. Someday, Mary Jane residents unhappy about the scheme's collapse may end up on your doorstep complaining, "Why didn't you regulate this properly when you approved the subdivision?" I'm not against development on Mary Jane Lake. I just want to see the development better informed and more clearly consistent with maintaining the remote and unspoiled character that's desired by the undeveloped lakes policies in your OP. Exactly where and how these three assessments should be completed along the path between today and final approval, I leave to you and your staff advisors. Thank you for your time and consideration. I'd be happy to answer any questions.
Thank you, Mr. Usher. Would there be anyone else who wishes to speak in opposition to what the Planning Committee has in our recommendation now? Oh, then, Mr. Ross, I believe you're up again.
Thank you very much, Madam Chair. And just for clarity, you had mentioned at the outset that discussion would be limited to the discussions of B17 and the other request of species at risk. Is that correct?
Well, what I really was trying to say was we have 300 pages here that we've all read several times.
Yes.
So we are well aware of the material that's here. So what we're looking for now is information that we may not have had, or if you felt that there was some confusion on it. And I think that has been answered. The part about have you done the studies has been answered quite specifically.
Okay, thank you very much. Okay. Thank you very much. I won't digress and address the other issues that were raised today. I will mention that, my point wasn't, hey, we've done the studies, because we're not talking about the studies. We're talking about who is to be satisfied. And I submit and will concede to Mr. Usher and his assertion that the studies he has requested differ in form of protocol from those that occurred. And there could be many studies and many protocols and many different stations and many different manners in which, different places to test to achieve different studies. But the point is, standards were established. The protocols, the review processes, they were established at the outset of our application. Township and district staff attended the meetings, and I would urge council to please, request of staff members who attended our consultation meetings and have been worked with us along the way as to whether or not the directive and the instruction has occurred, because we have followed those instructions. So if the peer review work isn't to be relied upon, then what's the point of the peer review? If the instruction to follow MNRF protocol isn't to be relied upon, then what is the point of utilizing the MNRF in any way, shape, or form? The standards are the standards. They either are standards or they're not standards. So that's the point that I'd like to make that is different. Now, the B17 piece, you had asked, I recall, in the meeting in December of Mr. Allen if the EIS spoke specifically to B17, to which he responded no. And he did indicate that substantively the elements of B17 were contained, elements were contained in the, and I'm paraphrasing, but were contained in the EIS submission. What he did fail to mention, or what maybe it wasn't asked because it was a subsequent submission to the EIS and a subsequent submission to the public hearing in July. But the 6 elements of B17 were thoroughly addressed by Mr. Hunter's November 1st submission to the township. It was a 27-page submission that touched on all elements that came about through submissions made by and questions raised at our public hearing. And those 6 elements of B17 have been thoroughly addressed in the 27 pages. I can go through them, but they're not scientific in nature, but there has been a scientific opinion and work submitted by Mr. Shaw prior to this meeting. So that is new information for you. I'll continue on then regarding, pardon me?
Can you summarize where you have 5 minutes, and we're going to try and keep to that a little bit, but I don't want to miss anything you're saying either, Mr. Rowe.
Okay, thank you. The standard for protocol and review, or is it the gospel of another biologist who works for an opponent? That's what I want to know today. What will the standard of review be? Because I asked that question and I can rightfully do so under the Planning Act, and I asked that question 3 years ago. At great expense, we prepared for and had the meetings necessary to clearly lay out the path forward. Okay, so what I see today is a biologist who works for an opponent who would like a different standard. Okay, keep in mind that the submissions that come at the 11th hour by opponents, these biologists have never been on our property. These are desktop opinions. We have a 60-foot ridge of rock that runs between Carlingford Road and Mary Jane Lake. Our property happens to be 270 acres. Carlingford Road is all the way to the south. The significant Bruce Lake wetlands is just south of Carlingford Road. I'm just rebutting that. Now I'd like to say the species at risk piece has been clearly addressed. We have followed the protocol of the MNRF, and I think perhaps I'll rest at that. And I would definitely invite questions, and I definitely would be available for anybody who would like to speak to me on it.
Thank you, Mr. Ross.
Thank you.
So what I would like to do now is, and I'll look to you, Mr. Allen, I would like either you first or the district. I just want to make sure that we're completely clear on this as this came back to us from council on the reports that have been done, on in terms of what's needed. Maybe we'll start at the district, if you don't mind, Mrs. Soya, seeing as you're doing the ultimate yes/no on this. So I think what I want to do is make sure that we all understand if planning is satisfied with what's going on here.
Thank you, Madam Chair, and good morning, members of the committee. Yes, I'd like to, take this opportunity to just provide a brief summary of the process that we've gone through, and starting with the application. The application was submitted to the district and deemed complete June 2019, and prior to that, we pre-consulted with, the applicant pre-consulted with district staff. And at those meetings, the purpose really is to lay out what is required as part of a complete application, so that when it does come in, we're prepared to, hopefully, we've seen it before and we know what is going to be in that application. So at the time, there was 4 studies requested and then also submitted. Those were the functional servicing report, the environmental impact study, and the wildland fire assessment, and then also a planning justification report. And the environmental impact study and also the wildland fire assessment were peer-reviewed. The district selects a third-party peer reviewer to confirm the methodologies and conclusions of both those studies. In Muskoka, that's typically done, I mean, it's done elsewhere in the province as well, but Muskoka particularly, it's important because we also do not have a biologist on staff to review those, and we don't have a conservation authority, so we definitely like to go through that step, and that's the usual procedure. And then the species at risk, the study is also sent to the MNR, the Ministry of Natural Resources and Forestry at the time, and that to look at the species at risk component of that study. So that peer review process was, there was some back and forth, and at one point the district facilitated a meeting or mediated a meeting between Riverstone Environmental, the author of the EIS, and Palmer Environmental, the peer reviewer, to just facilitate a discussion, and through that, Riverstone did some additional work and provided some more clarification that the peer reviewer was asking for. So then the peer review was completed after that process, and the peer reviewer accepted did not have any additional concerns with any of the methodologies that were that the surveys that were completed, and there's a few minor additional asks that were asked for in terms of mapping, and some additional very kind of clarification of the additional work that was done. So then the species at risk component review from the ministry, that came back, and as has been noted several times, that the ministry did not have any additional concerns. They agreed with the surveys that were completed at the time. So so that is basically the review of the environmental studies. There was also no concerns identified by the peer reviewer for the wildland fire assessment. So then I would just like to also, I know this has come up several times with regards to water quality of the lake. I can now report that there's some preliminary data that's come back from the study of that lake. So the district had approached Mr. Ross to ask if the lake could be sampled as part of the sampling program from the district. He did agree to that, and last summer there was the first samples ever taken as part of that program in that lake. The intent there is to establish a baseline, and it was also an interesting lake for the district to start sampling, because there was no development on that lake currently. It will take several years to see trends. For the most part, the data that was collected appears to show that it's generally a quite nutrient-poor lake. Oligotrophic is the trophic state that it is likely going to be in, but again, that will require additional testing, which will probably happen next summer. So then in terms of process, I would just, I guess, like to explain that, or just to make it, just to outline the process going forward, that the district has received the plan of subdivision application, and we need to move forward with that. And we have not completed our planning analysis completely. We've completed the reviews of the studies, and we are, we've circulated for comments, and that's large part why we're here today, is to receive comments from the township prior to us, and from the public, obviously, prior to us completing our planning analysis and then taking it forward to our committee. So I would, I guess in that sense, just like to ask committee to take, even it, I mean, regardless of how the discussion, the further discussion goes today, it, committee may want to, well, this would be the opportunity to provide comments to the district for when it is considered by the district, if there are any specific conditions that the township would like to have considered by district committee. And if there's any other questions, I'd be happy to answer those.
Before you answer, I'm just going to see, Mr. Allen, do you have anything to add to that? In terms of the history and our planning department and what your recommendations?
Thank you. Through you, Mr. Soya has done an excellent job explaining the chronology of events and the studies that have been completed. I would note that staff had brought an informational report to the first public meeting in December of last year. We subsequently brought forward another report when this application returned for further consideration with a recommendation. Staff had provided a list of potential conditions or recommendations that could be forwarded to the district if the committee wanted to forward those on. The committee ultimately decided to defer submitting any applications and requested 2 additional studies be completed, which you alluded to in your opening remarks. And I guess lastly, the last report that we brought forward specifically contained a section where staff acknowledged that the development conformed with the district official plan, the township's official plan, and was consistent with the provincial policy statement.
Thank you. Thank you. Okay, so do we have questions? Mayor Harding?
If I may, I'd like to go straight to comment if I can. We've debated this now back in June. We did this in December. Thanks, Sam. I think it's probably okay. To Mr. Usher, your first comment about that we've already made a decision on this and we should follow through with it. The process that this council should do is our committee makes a recommendation to town council, and town council either agrees or disagrees with that. Unfortunately, what happened 2 months ago is the committee didn't actually make a recommendation to council. We sort of made a recommendation to ourselves to go back and do studies, but council never got an opportunity to chime in on it. So we couldn't say yes or no as a body of council, and that's what's happening. It got referred back to this committee to come from here for council to actually make a recommendation. So I just want to make sure we're comfortable on that. I will say what I have heard quite clearly is that 3 years ago we gave Mr. Ross a development roadmap. We've asked for certain processes that the district has, and let me clarify, these are the standards you need to meet. These are the studies that have to be done. They have to be peer reviewed. He's followed that roadmap. He's executed those to the regulatory authorities, the MNRF, and so on. I'm concerned that our council, I've used these words before, overstep our bounds, because I'll use the equation that we've asked Mr. Ross to build a home to Ontario Building Code. These are the regulatory things, the Ontario Building Code. And now he's done so, said, here's how I'm going to build my home, and somebody has come in and said, no, we want it to be an R2000 home. We want greater standards, not what the baseline is, and I look at it with 10 lots, I think he's done greater standards. Or the province has a speed limit of 100 kilometers an hour down the road, and he's done 80, but some people say, no, I think your speed limit should be 40 on the road. And there are regulatory that is not ours, and I am quite confident that our planning staff and their comments should be provided to the regulatory authority going forward. So I would like to move that forward.
Any other comments? Okay, so just in terms of process before I go there, we can move this forward if we still feel, if the committee feels they want to recommend that these studies be done, that can move forward for the district to decide. But I don't want to sort of do that unless you really feel that that's what you want. In other words, you make the decision here on that. So I didn't say that very well. Maybe I did. I just don't want, I mean, let's not just take it off our plate to put it somewhere else is what I'm really trying to say. So, Councillor Roberts?
So, I'm just protocol, I would like to comment back to the district what they asked for. When do I do that? After the resolution is read?
I have a resolution here.
Right now, so I can make a, okay, thank you. Okay, Mr. Soya, I was very encouraged that the district has done their water testing on Mary Jane Lake. That's been one of my concerns from the very first day I read this report, because it's a prime opportunity for us to set a baseline, and I'm really glad we've done that. And my comment being is that you need to I think sure you will, but the district needs to get in there every year or whenever they feel appropriate to get this done. But in the event that there is a problem detected, they need to take strong action to mitigate the change that's happening on Mary Jane Lake. And that's what I'd like my comment.
Councillor Nishikawa?
Thank you. When the application first came forward to us, and reading the reports from Riverzone and other reports, I had strong concerns that stuff was missing. But I didn't know what that stuff was. So I went to my resources. So I had 3 biologists, one very well-renowned biologist, comment on this application and what I should be looking for. And it was interesting because the information that was gathered was that, in fact, this lake was supposed to be under a study by the province 11 years ago. And that somebody dropped the ball. The province dropped the ball, I'll say. One thing that we haven't discussed here is that the big concern, apparently, with these biologists is the spiny water filly, which is an invasive species. And because this lake is not developed, once it gets developed, you're opening up doors for that type of thing. Having said that, and there's a few other issues as well. Primarily, it came down to that I would suggest that, and I will bring this back to the district as well, we don't have the right protocols in place. We have had, through Watershed Council, recommendations, general recommendations. Watershed Council cannot speak on a specific application. So that's the important thing I think the public doesn't even understand. I would just say sadly that everywhere I looked and everything that I learned, and I'm grateful for this opportunity to try to learn more and better. But the reality is that higher levels, MNRF and all of the other confusion about, of those changes there, don't give us a lot of room to add our protection. Unfortunately, I have to rely on the applicant now, that, and them living on the property, that they will react to changes that they see from their development and try to mitigate it. I think that, you know, I actually did get some pretty good evidence that came back that, geez, you know, we should be doing more, but I don't believe that the challenge could meet an LPAT for hearing, for instance. And I have to look at what our tax-paying citizens would expect from me, and to do with their tax dollars. So at this point, I have to suggest that we move forward with the application. But I will be bringing what I've learned to the district and also to our own staff, because I truly believe that we're missing the boat. We are getting smarter every day, but in fact, we're not putting anything in place to try to protect some of those things. So that's what my comments at this point.
Well, I think our new official plan review, hopefully we will be able to capture some of what's gone on here. But right now we have our protocols and we have in place what we have in place that we can deal with. I mean, what we're asking, if we're going to rely on these reports and the peer reports, is to go above what the standard is at this point. That is my opinion.
Sorry, I also missed, I did want to mention the Blanding Turtles situation. Put a lot of effort into that, as well as going back to the Red Leaf days and things like that, when we had concerns about Bruce Lake. There was all of this, you know, everything flows, right? Everything, and ultimately, I would say again that both municipal, like, I'll just say from a municipal level, our public works departments, and that goes across the board, the district, everybody in public works, there needs to be an element of teaching or respect on what we do on beside wetlands. So for instance, Carlingford Road is a good example, but why I'm wanting to say this though is because in fact Carlingford Road has been raised and the Blanding Turtle sightings have been raised, but in fact there is also reports of actions that our own municipality have done over the years that don't support protecting the Blanding Turtles.
Okay, so I think we're going to, I hear you, but we're going to move back to being directed at this. Councillor Edwards?
Yes, I think that we've had the studies and that, and I had a phone conversation with Mr. Ross, and what I was more concerned about, being a lake that's not developed, is more testing done on it. He sort of agreed to that. And I asked him at that time if he got the 10 lots, if he'd put a holding on, say, 6 lots, get 4, do more testing, and then release 3 more, and then test, and then the other. He seemed to be in agreement. I would hope that he would still be in agreement with that, because I think that's an excellent time to be testing lakes that are not developed, and then we will know what development does to lakes in the future. And if he would do that, like I would take this and say, okay, move it on to the district without the extra reports.
Excuse me, Mr. Roy, no, I'm going to ask you, is that something that you would be willing to entertain?
Thank you very much, Madam Chair. Councillor Edwards, yes, with respect to the discussions that we've had, and you did raise this point in December as well, I think phasing the lots and the district would support me when I ask for their memory to be refreshed. We seek a phasing plan that extends beyond that of current rules, because the current rules would be such that we would need to record the 10 lots within, I believe, 3 years, and then there's the opportunity for one extension. We're looking for a broad extension in phasing. And what I'd like to do is be able to sit down, have the opportunity to sit down, perhaps Councillor Edwards, if he would be willing, and the district, moving forward prior to our application being heard at district, and clearly establish the parameters of the type of phasing that would be amenable between what Councillor Edwards is suggesting and what the district may or may not be willing to agree to. We have a long-term vision on this. I've said it before, I'm not looking to go to the market with 10 lots today. What I'd like is ideally to have fewer owners rather than more owners, and I'm simply reacting to something that I was told I had to do. Phasing is a very important opportunity for us all, and if you'd be willing, sir, perhaps we could get with the district.
I'm on the committee there, and I'd be glad to sit down with Mr. Ross, because I think this is a chance for us to get water quality and check it out. So I'm excited that Mr. Ross would go into this.
And prior to the public hearing in July, I had been contacted by the district's water testing program. I don't know whether it was related to my application or not, as I don't believe our application was complete when they contacted me. But we immediately agreed to water testing to begin immediately, and I believe they were on the site several times through the season. I haven't had any information from them, but I have indicated that they're welcome to continue so long as they wish in perpetuity. We simply would request notice when they come on the property. Thanks.
Okay, thank you. In terms of what the discussion we have just heard, I'm sorry, I'll wait and let you ask your question, Councillor Jaglowitz.
Thank you, Chair. It actually wasn't a question. It was going to be a suggestion. It would appear to me that there's appetite here to revisit this today and to pass this on to the district. And if that is the case, which I'm assuming, then I think we should be very clear in what we're recommending to the district. And what I'd like to suggest, and I'm prepared to make this in the form of a motion if you wish, but I'd like you to consider it seriously, that we ask the district to consider requesting that those 2 studies that were asked for be completed. That will be their decision, but that we recommend that they look at that. We can't control what they do, but that we thought that was important in December. I don't see why we shouldn't still think it's important. Secondly, that we endorse the suggestion by Councillor Edwards, and it appears to be okay, that this proceed in phases, and that the first phase, that there be a solid stop at the end of the first phase, which is 3 or 4 lots, depending on how it works, and that the water quality studies that are taking place be studied, and that there be assurance that there is no harm before the next phase proceeds. And then the other element that was discussed in December, and that was the way to the regulatory framework to control the watercraft usage of that lake. And a suggestion has been through a road association, but I'd like to suggest that we ask the district to ensure that their legal department is satisfied that whatever regulatory framework is put in place by the applicant, that it's something that can be legally enforced. And that if, so my suggestion will be that we put those in, that be our comments to the district. Now, I was going to add one further, but I haven't. And just so you're aware, I listened to reason. I think the boating study was requested, and I think that the water quality studies likely will satisfy that requirement. So I'm happy to move that if that's a
Councillor Edwards?
Comment. Actually, and this is through the planning staff, if they came up with a lake plan, then it could be in our official plan, could it not, Mr. Pink, and that they could limit boats as well. That. So, I mean, I think there's protection there. I'm satisfied with it. I don't think we need the extra study, and if the district wanted to ask for a study, the opponent's agent could ask the district for that, but I think at this point I would just pass it on as it is.
So help me with that, I'm a little confused. You'll pass it on with no studies?
That's right, yeah.
Thank you, okay.
Yeah. And the district can make that decision if they do, so they actually desire, they're here, they're listening, so
Yes.
we'll leave it up to the experts.
Okay, okay. Mayor Harding?
I agree with that 100%, and I don't think any new studies are needed. I believe our planning staff have made recommendation on all of the development and what should proceed, and I think that should go to the district. I like Councillor Edwards' comments about a lake plan, and Mr. Ross, I mean, basically, you embed that in an OP, and it talks about how the lake is developed, types of boats and everything else can go in there. I think that's a prime example to display your stewardship going forward in the OP. So I don't think that needs to be specifically in a resolution right now, and I think that yourself and Mr. Sawyer can work your way through some of that.
Any other comments? Okay, so what I am hearing here is we're going to send our comments back to district, and we are not requesting any studies at this time? Well, I've got to have to see if we have
No, I
consensus on
recommended
it.
that we
Yes,
ask them to consider whether they
I know you
believe.
did, that's why I'm bringing it up right now, okay?
We're not telling them to do the studies.
I hear that.
We're suggesting.
But my understanding from here is we don't even need to make that suggestion at this point. So I'm going to, and you agree with that, Councillor Roberts? And Councillor Nishikawa, do you want to weigh in on this? Okay. All right. So, little unusual, but we will ask you, because if it's something to do with what we'd like to do, Mr. Ross, we would like to hear from you.
Super quick. Okay, the concept of extra studies, as an applicant, relating to the species at risk, we are reluctant to be amenable to extra studies because of the nature of the tribunal being unbiased in terms of who has set the standards. And we are willing to move forward along those lines. Performing extra studies when we've satisfied the only unbiased tribunal is something that we're not interested in doing.
We were just removing those studies, as a matter of fact.
Thank you.
So, yeah. Okay, so I would like to, if we can amend, I think we need to amend this. David, thank you. So we're going to, the consensus is no studies, but I don't know how you word the suggestion by Councillor Edwards. Well, a lake plan would be great, and then the holding to work with district. These are comments to pass on, right?
And
Consideration of phasing. Yes,
phasing
Councillor.
and the legal framework.
Also, I thought I heard the recommendations of planning in the. there
Oh,
was a
yes,
set of
they're
okay,
in
all
here
right.
already. Okay, do we want the legal framework for the boating? Anybody? I don't even know how you begin to enforce that, and I don't know that the district would want it, but if that's the wish of this committee, we'll include it. I am not in favor of that, so no, we're not including that.
But we are including the phasing with a stop between phases, with a water quality check that is done before the next phase proceeds.
I believe that this is part of a study that's going to be done by the district. I think Mr. Ross is happy to have that.
But the understanding was that the phase, usually the phasing's at the discretion of the applicant. In this case, the phasing would have a hold on it. Yes, so that should be clear. Yep.
Okay. Yeah, Councillor Roberts?
Yeah, thank you. And also that if there is an issue, that mitigation steps are managed by the district.
I don't agree with that.
You don't?
This is private property, and I don't. What do you mean?
Back to you, the lake is not private property.
So,
Okay,
I'm
so it's
sorry,
a-
Mr. Sawyer, let's let Mr. Sawyer.
No, I just wanted to, I guess, if there was any confusion with regards to what through the plan of subdivision process, what would be possible. I mean, there is always the possibility to build phasing into a plan of subdivision approval. And a subdivision can be just that, have a phasing schedule and it be approved in phases. Not requiring specifically to be done through holding provisions or something like that. But, so that, I mean, that is an option that could be discussed. It has not been discussed with district staff, potentially at a very cursory level, but it's not been part of the application so far. So that would be something new for the district to consider. That's it.
We'll just send our comments along. Okay. It's Mayor Harding.
So I think that somewhere we need to capture in this that the town council would like to look at a form of phasing to ensure that the development is appropriate on the lake without negative impacts. However that is, I'll leave that to smarter brains than myself and better planners than myself to work with the applicant to get to that, and it may be some more environmental. I don't know if there's benchmarks and there's water quality, because at the end of the day, whatever you do is going to have some changes. So what's negative? We can't answer that today. I think we just suggest that we would like to look at some form of phasing on this property development. I think that's the only comment. Mr. Payne.
Yes, I believe so. Yes, I can see, I can. Oh, I'm sorry, Councillor Mazin. Please.
Sorry, just the clarification on Councillor Roberts' question. I think the ask was around mitigation for if there was an impact on water quality. And I wanted to understand better that question.
I probably need somebody from the district to answer that. Would you be able to answer that for us, Mr. Sawyer?
Through you, Madam Chair. Would you just be able to I guess, restate the question? I'm not sure if I am able to answer it, but this is like specifically what the water quality question is.
I have in-depth experience in water testing, as you're probably aware. And we being different groups, have communicated to the district that we have grave concerns, very grave concerns, on the deterioration of water quality in Muskoka. And the district listens, but in my opinion, could move faster to curtail the destruction of our water quality. So what I'm trying to get across in this is, you're doing water testing. We're doing water testing to see if there's a change, or you're doing a baseline, and then you're going to see it. But when you see something occur, you don't say, I'm going to do a causation study that's going to be done in 4 years. You immediately need to take action to stop any more development until that is the cause is satisfied. It could be climate change, but I believe we need to do that. If we have known facts, stop and don't make a 100-year mistake. So I don't know how you get to.
Yeah, I was going to say, I'm not quite sure that we can even discuss that at this level in terms of that kind of detail.
Well,
sorry, let's let our CAO.
Madam Chair, it would appear to me that the phasing approach that's being suggested may accomplish that aim, and I guess I would see if that satisfies the member.
Yes, I'm hoping it does, but I'm saying if they're confronted with an issue, then there's got to be, go to door 1 or door 2.
Well, I think that's probably a policy. It isn't just this one place, but that's my comment. Councillor Nishikawa?
Very much that. And the interesting thing we've seen, well, I'll just talk about, like Joseph, for instance, we know that it takes many years to see the damage done. I don't know the number of what that phasing in looks like and where we can see the mitigation or the effects, the effects on the lake. Again, I have to stress that I don't believe that like, it's a great wish list that we could do all of these things, but in fact, it is not in our mandate. That we don't have the tools and the ability, nor does the district, I will suggest. And because all of this stuff takes time to show up, which may not work along the holding zones. I mean, it's just the reality. I'm just trying to say. So mostly, I really, really stress that we need to put some faith in the developer of the property. That they're going to stay on the property and they're going to care. Because as much as we can say all kinds of things on hard paper, the reality is of how their impact is going to be. And I have to, at this point, trust in the applicant, because that's all I got.
That's every application, as a matter of fact. So there you go. Okay, so I think,
But I can shame them.
Council that comments be sent to the District Municipality of Muskoka advising that should they wish to approve plan of subdivision application S 2018-7 Ross, roll number 4-18-075/076, that it be subject to the following. That a zoning bylaw amendment be passed to implement the environmental protection recommendations and mapping of the environmental impact study prepared by Riverstone Environmental Solutions, Inc., dated July 2018, and that the EIS addendum prepared by Riverstone Environmental Solutions, Inc., dated June 7th, 2018, to change the rural RU2 zoning for the waterfront lots to waterfront residential WR 8-7, to lift the holding symbol, to limit each waterfront lot to a singular dock save for the launch ramp, and to prevent two tiers of waterfront development. Secondly, that a subdivision agreement with the township under Section 5126 of the Planning Act be entered into, wherein the owners agree to implement and abide by the recommendations of the environmental impact study prepared by Riverstone Environmental Solutions, Inc., dated July 2017, the EIS addendum prepared by Riverstone Environmental Solutions, Inc., dated June 7th, 2018, the wildland fire assessment prepared by Riverstone Environmental Solutions, Inc., dated May 2019, the functional servicing review prepared by Tatham Engineering, dated July 3rd, 2018, and the addendum to the functional servicing review prepared by Tatham Engineering, dated June 5th, 2019. This is to be registered on title of the entire subject lands. Next, that any requirements identified by the Township's Public Works Department regarding access and maintenance be satisfied, that any requirements identified by the Fire Chief and the Township's Emergency Services Department regarding access and the provision of emergency services be satisfied, that the proposed lots be made subject to site plan control, that cash in lieu of parkland be dedicated to the Township in the amount of 5% of the assessed value of the newly created vacant lots, or the entire lands, whichever is less, and that the plan of subdivision be phased, with each phase proceeding upon the submission of satisfactory water control sampling results. More here? No, that's it. Okay, that's it. What? Oh, water quality, not sampling, sorry. Water quality sampling results. Okay, any discussion? No? All right, I'm going to call for all those in favor? Opposed? Carried. Now I'm going to suggest we take a lunch break, and we'll be back at 1 o'clock.
You're welcome to take it, but it doesn't have a name.
clear the direction from council is to have one umbrella vision statement for the strategic plan and official plan review. So that is essentially changed. It will likely not be part of the workshop discussion on. Out of the report, and one section of the official plan review has to do with tourist resorts. I think as we all are generally aware, the District of Muskoka recently updated their official plan, and they received an extensive amount of feedback on waterfront commercial or tourist resort uses, to the point where they ended up passing an amendment to their current plan and leaving the existing policies in place and directing their staff to review that issue in the future. And due to timing urgencies with respect to Minette, that project was slated first, with tourist resorts to occur after. So given, we'll call it a little bit of a policy vacuum at the district level with respect to resorts, again, there's lengthy background information in the background discussion paper. Really, staff's recommendation, and the consultants would agree. I think it would be premature to dive into that issue at the township official plan level until the District of Muskoka reviews its policies, and then we can go from there. I've suggested, just in the interest of some efficiencies, it could be a joint project with the district, and it would, I think, certainly at this time, I wouldn't recommend undertaking the project. I think this summer there will be a lot of consultation on Minette and the official plan. I think it will be confusing for the public to include tourist resorts in that as an entirely separate project. So I think we will see how the first two processes play out and take on the tourist resort policy framework upon their completion. Lastly, what you have before you is a very large document. It's a compilation, again, of all the background papers that have been prepared by the consultants. They were in front of you previously. I believe it was the December Planning Committee meeting. There are 3 sections that are new, and would be interested in some comments from committee, which I can relay to the consultants on those 3 new sections. In particular, flooding policies, which is section 6, and we can work through some of the questions. They're on page, I believe it's 59 in the document. It poses, 62, page 62. I think we're generally aware of the flooding issues that we've been experiencing in the township, and floodplain mapping is going to be released by the district. I believe it is on Tuesday at their meeting, which will be incorporated into our plan and zoning bylaw. What the consultants have put there are a couple of questions for members to ponder with respect to what restrictions or prohibitions may be appropriate or could be considered as part of the official plan process with respect to flooding. And then lastly, the other 2 new sections, and I believe they pose 2 fairly straightforward questions, which again, happy to hear committee members' comments, are on urban design, section 12, and economic growth, section 13. So I'll leave my comments at that, and happy to answer any questions. And again, happy to hear any feedback that councillors have on those questions posed on page 62. Thank you.
Thank you, Mr. Pink. Is there anyone here who might like to, from our audience, Lawton, who might like to speak? So please, Mr. Ulster, come on up.
My address is 1052 Longhurst Road in Windermere. Thank you, Chair Bridgman, for allowing me to speak at this short notice. I appreciate that, and thanks to the other councillors as well. I'm speaking on behalf of the Muskoka Lakes Association and the Friends of Muskoka. Last night, you should have all received an email with a letter from the MLA and Friends about the official plan review, which is at item 6A on the agenda. As Susan Eplett mentioned, on Wednesday, we believe the township should have one umbrella vision. And this vision statement will guide us all of our activities and decisions, and that reflects the community's input. Last summer, the community gave extensive input into the township's new vision, and it's clear that the community believes the environment is our economy. And the township should adopt an environment-first principle. We strongly encourage the township to adopt a vision that recognizes the link between our environment and our economic prosperity. There can be no balancing or trade-off between the environment and economic growth. We can choose to develop and grow in an environmentally friendly manner, as the community clearly wants us to do. Director Pink's report lists the 2 vision statements proposed by Laura Consultants. In our view, neither of these visions reflects the link between protecting our environment and the success of our economy. In addition, the first alternative only protects Muskoka's environment for climate resilience. We encourage you to support the vision statement circulated to Council by the MLA, since it creates the needed link between environmental protection and economic success. And it reflects the values of our approximately 6,500 combined members and their aspirations for Muskoka's future. You've all read this and heard it, but I'm going to read it out again. This is our MLA vision statement. The unique character of Muskoka Lake's natural and cultural environment is understood, valued, protected, and enhanced. It is at the core of a sustainable and thriving community and will be passed on to future generations. Future generations is really important. Finally, we agree with Director Pink's recommendations that the resort policies be reviewed after the Manette policies are finalized. However, if the Manette policies are finalized before the official plan review is completed, we encourage the township to include the resort policies in the official plan review. Thanks very much, Chair.
Thank you, Mr. Osler. Any questions of Mr. Osler? No. Okay. Okay, thank you. I'm sorry, Councillor Roberts? For comments? Yes. Yeah, oh, no, I don't think it's to Mr. Osler, right?
Oh, is he done? Okay.
No,
Sorry.
no, he's, we'll just keep you standing up and sitting down.
No, I'm good, thank you. Yeah, so, okay, on the official plan, it's very important that we all understand that the consultant did exactly what we asked them to do on the background discussion papers. They were asked to provide a background information on focus policy topics that were listed in the RFP. They identified issues, they offered recommendations on policies and approaches, and the suggested policy option considerations. It must be noted and very clear to all that these background discussion papers are those of Meridian. And the content of those documents are not fully supported by some of the working committee. Many are. So, because I've been getting from some of the public that they thought that the reports that were set in December were the council's views. And so I've talked to them, say, no, they're not the council's views. They're excellent documents to give us background and help us, coach us in the right direction. Now, what has happened with this one, as Mr. Pink was talking about, is that we did see them in November, Part A. We did see Part B in the memorandums. And then recently, on February the 6th, they gave a new version that brought all those documents together with little change, because I went through and reviewed every one of them. But they added 3 more sections. What we have done is, and I apologize for this, we've inadvertently not included the official plan review working committee. And I brought this to the attention of Mr. Pink, and he has worked with me and suggested that he will reach out to all the working committee members and ask for their comments on those 3 new sections, and we're not going to convene a meeting. The reason we're not going to convene a meeting, it's really the consultant's views. and they're asking for our input. So they're not, we're not blessing this document. This is an information document. So that's what the next step, Mr. Pink, I agree with how I summarized that. And we're going to have that done before we step on towards the policy direction. And with that, it's key and important and imperative that every council read that document in detail, so they come prepared to go to work in the policy direction, specifically the PPS and the district and the districts, and it's just chock full of recommendations, etc. Now, I have talked to a few of my peers on the OP review committee, and they wanted me to express, which is now a little bit off topic, and I apologize for this, their concerns that we spent 6 to 8 hours meeting with the consultant and giving them input. But from their review, they don't see that information sharing reflected in the background discussion papers. So I talked to Mr. Pink about this, and he said that really wasn't the intent. Maybe Mr. Pink can expand on it, but in going forward, we'll make sure we involve the working committee before we bring it to planning committee, unless the process change. And so with the final comment, I respectfully ask that we do not discuss the 3 new sections, and that we send, as we have asked the working committee, we'll be asking the working committee, we send our comments directly to Mr. Pink, who will share it with the consultant.
Thank you. So I think what I'm hearing, just so I'm clear on this, Councillor Roberts, the working committee hasn't had a chance to have their input for some of this. And so rather than us discuss it, let's wait till we get the input from the working committee, and then we'll discuss it. Okay, that's, okay?
Clarification?
Yes.
I don't think we'll have time to discuss it, because we're attempting to do the policy direction meeting in April. So we might be able to do it in March. This is February, but I don't know, back to you, maybe Mr. Pink wants to add something. I don't think we need another meeting, as per se.
Okay, so I guess to help me out on this, my question would be, what is the downside of us at least talking about it a little bit today? Just getting familiar with it.
I guess if committee would like to, I'm not going to, but if they'd like to ask questions that have come prepared, that's good. I think the working committee, the process is the working committee is supposed to look at it first, and you know, get their, and then, and we're not going to have any dialogue with them. They're just going to send their comments,
right,
as a workaround. Okay.
Will be.
That's. But I can. I'm whatever you want to do.
That's fine. Do you have any comments, Mr. Pink?
I think, thank you, Chair, Member Roberts. As a good sort of summary, I would just clarify maybe or touch on a couple minor points. Really, the only reason those 3 sections weren't before the working committee prior, just to happen of timing, the 2 meetings we had in November and December to touch on it, those 3 sections weren't prepared. I don't know if it's you know, a good expense of the funds for this project to meet again to touch on those. I think the flooding section is certainly important. But the other really main clarification I'd make is hearing that you know, the committee members feel that their input wasn't taken into account. These are background papers that are really more factual based. I think you mentioned there's recommendations in there. I don't believe there's really recommendations. They touch on the issue at hand. They provide background data, what policies say at the provincial level, district level, current policies say, and then they propose suggestions or ideas or options that could go forward. And they were used as, like I think I mentioned to a few committee members, a lot of official plan review projects won't even involve a committee, working committee or planning committee at this stage. They really just use the working committee as a sounding board to see, you know, of those options or suggestions or paths we may choose on these topics, where was the community leaning? And I think we'll see the results of that at the next stage or future stages. I don't really think sort of recommendations or opinions are going to come in the background papers if that's what you're looking for. I'm more than happy to forward the complete document, of course, and highlight the 3 sections for committee. And they can certainly forward their comments to the consultants through me. And I think certainly we're here, the documents on the agenda. I think it would be useful to hear what councillors have to say regarding, like I say, some of the questions that are posed, because I'd like to transfer or pass on those comments to our consultants so they can put that thinking into place when they're preparing the policy recommendations or the directions document next. So I'm happy to do that, the order of which I'm less concerned about the fact that, as I say, Planning Committee is discussing it first. I think all comments will be taken into account.
Okay, so just help me. I just have one clarification, Mr. Pink. So those comments that were in your committee that you didn't see in this paper, will those be in the policy papers? I guess how does this committee understand what was discussed there and some of the ideas that came through? That's all I'm interested. That's what I'm wondering.
So during those meetings, and when it was when the previous documents were for Planning Committee, the consultants and myself were taking notes as to members' positions. And like I say, the working group was more meant as a sounding board for the consultants to bounce ideas off of. I think you're going to see the outcome of some of those, some of that feedback at the next stage when we meet as a workshop to talk about policy directions. And I think there's certainly a desire amongst committee, I know, to get into the meat of this. And I'm hoping that workshop on April 3rd is that first step where you really start making some more concrete decisions on directions that we may be going, and then getting some public feedback on that. It's been fairly high level to date, and preparing the base, the background. The planning process is subject to appeals, and you need to provide the substantiation and the research that you provided this background, so that when later decisions are made, you can fall back on your research that you conducted, and it wasn't sort of random. So hope that helps.
Thank you. Yes. Councillor Jaglowitz?
Yes, through you. I'd like to comment that I found this background document excellent. I've got it in a 3-ring binder, and I suggest other people might want to do that because it collects the PPS, the OP, district OP, ROP, zoning all into one place, and obviously I read through 3/4 of it, but it's a tough read. But as we get into each section, I think it'll be very, very, very helpful. So I found that. What I'd like to do also, with your permission, is to just comment on the recommendation that's come forward. And I too have a concern that the resorts might get lost in the process. I understand the need to not confuse the public, and so I don't have an issue with them being discussed at a later date. But if I'd make a friendly amendment to that recommendation to see if you would be agreeable, and just delete the last part, put a period after Muskoka, and delete the part that says "and not be updated as part of the township official plan review work program." In other words, it's going to be reviewed as part of a future joint comprehensive planning process with the district, and it may or may not end up in the final document depending on the timing. I just don't think it should be a foregone conclusion that section is now, we're removing it from our OP review. That would be my, I don't know how others feel on that.
Any comments on that? Sorry, Councillor Roberts?
If I understand my fellow councillor, it's really basically a timing thing.
Mm-hmm.
So you're saying, let's work jointly with them, but reserve back what we're going to do after we work with them. That's correct?
Yes, if it can be completed in time, it should form part. If it can't, I think what you're saying is you don't want to hold it up, but I don't think it should be left off the table. Like the district have left it off the table, and now they don't know what to do with it. The other thing I'll comment is that when I read this, one of the first questions a consultant asks us is, should this be an amendment to our OP, or should it be a complete revision of our OP? And I'm kind of leaning towards a complete revision, and if you do that, then you can't leave sections out, in my mind. So if it delay, in other words, if the process takes an additional 3 months and it can include the resorts, maybe that should be, but if it's going to be years, then not. So I just think taking that tail end off just leaves it open.
Do you have any comment on that, Mr. Pink?
I'm certainly fine with that. I think that's a good suggestion. Certainly, I don't think we need to be committal now that it's definitely not going to be part of the official plan, so I recognize that. I would just comment, just quickly, I think you referenced if it's an extra 3 months. Keep in mind, I think the official, the tourist resort review will probably be a lengthy process with a lot of consultation during the summer months. So I think in order to roll it in, you're probably looking at quite an extended official plan review process. I don't think it would be just a matter of a few extra months to combine the two, but I'm certainly happy with sort of deleting that end of the sentence for now, and we can revisit it as we work through the process. I think that's fine.
You would like to go through these 3 sections in particular? Right? So the policy consideration number 16?
If members had comments or suggestions, I'm happy to make notes, as I say, and forward those to our consultants. As I think I don't need to go through the background. I think everyone's familiar with the flooding issues we're having and the number of advisors indicating that it's likely to continue in the future. Certainly in the advisors report to the province, they've suggested prohibiting boathouses or potential ministerial order prohibiting docks and boathouses on the waterfront. I don't know if there's a political appetite for that, but the consultants have proposed some other options or suggestions or ideas that I think certainly myself and the consultants would be interested to hear committee members' thoughts on those suggestions. They sort of range from some less passive, just sort of acknowledgement in potential future agreements, to some quite more concrete and proactive, including significantly reducing the size of boathouses and limiting what can be built over the water through a future zoning bylaw. So interested to hear committee members' comments if there are any.
Mayor Hardy?
Happy to chime in. Just one point in this document, page 305 of our agenda package, page 59 of the document. I'd like a photo credit, please. It's off my Instagram account that they stole. I have a hard time. I struggle with A and B in policy 16. C and D I don't have an issue with. E and F I struggle with as well. That's sort of my basic high-level comments. I've said before that boathouses are an iconic part of Muskoka Lakes, and we will lose much of our charm, if you will, to change those going forward. So I can just tell you I would not be in favor of that.
Anyone else? Well, I just, as I'm looking at this, and I'm looking at prohibiting large appliances such as washing machines, dryers, fridges, and stoves within boathouses, considering that we have a number of residents who seem to want to do what they want to do, could we phrase that on the first floor? I'm just thinking, that because I know we've had a number of people come back to us and say, well, you shouldn't be allowing us to do things that flooding could destroy, right? So I don't know. I just throw that out as a thought. Sorry, Mr. Pink.
Thank you. And that is largely the environment we currently reside in. There's a long history to boathouses, and it was the previous interim control bylaw looked at that type of use for those reasons. And you might have seen it in a few recent rezoning applications. The approach taken after that interim control bylaw and the study that was done was to require that the first story of the boathouse be one room only, thinking that that would address the problem. And now what we've since seen are a lack of slips in the boathouse, and still having the use. So it seems like architects and developers seem to be always one step ahead. But I would say largely now the intent is to prohibit those types of uses in the first story. We would allow them in the second. But that's certainly a helpful comment. I just thought some background might be helpful.
Councillor Jagowitz?
Yes, I would have a comment on the septic one, which I'll have to find it there now. D, in that currently people have in the boathouse, they have a septic on the main floor normally, and that would definitely be within any floodplain, I would think, right? I would gather. And so if that was changed, if I read that correctly, that might be a good thing, because possibly those shouldn't be on the main floor. Possibly the septic should be on the upper floor where those facilities would be. So I think maybe we have to look at all of these. An interesting comment is that the floodplain mapping report that's just been made available is another good background document. It's in the agenda package for the district for that 12:30 meeting, and it not only talks about floodplain, but it goes through the entire history of floods, what caused the problems, what's likely to happen in the future. And if I read it correctly, it basically says get used to it. Yeah. You know, get used to it. We're not going to do anything about it. So I would support a lot of these measures, but boy, if we go that route, we're going to have a lot more exceptions, aren't we?
Councillor Kelly?
Just a quick thought. We can be as prescriptive as we want to be, but I think before we do anything permanent or creating new rules and regulations, we're going to have to revisit our collective will and ability to enforce any of this stuff. We can write it all down, but as we've seen as I've seen certainly over the last 12 months, we don't seem able to wrangle it in even when we see a breach. So.
Okay. Mayor Harding?
Just I guess a clarification on that from a components of a septic system below the floodplain. Is that an elevation? And is that elevation now changed? I haven't seen I haven't had a chance to download the report from Monday yet, but have they provided a new elevation of, for example, Lake Muskoka in that mapping, or what? Because from an elevation perspective, you know, I live in a boathouse. I live upstairs. I have septic moves down as a holding tank on the first level so that it can be pumped back appropriately. But is that elevation to 2.9 meters, it should go now to 2.95? That's a question to me, and that's where I say I don't disagree with that, but what's the elevation of the height of that perspective? A holding tank could sit below the dock as long as the lid is well above the water, or the high elevation.
Councillor Jagowitz?
Yeah, if I can just ask, because I did read a lot of the report, what they basically did is they took the history of the levels and they charted them, and then they have a blue line that goes through and it projects out. And so they're projecting that with climate change and everything that's going on, the hard surfaces and everything, that the levels are on an increase. And they've actually calculated factors. Now, I don't know if it's that dramatic, but I think they're just saying get ready for, and maybe if someone else has read it, maybe I haven't read it technically, but in your case, for example, if you don't have a washroom on the main floor, if it's on the second floor, it wouldn't be that much of a hardship to have the septic moved up just under the second floor rather than sitting on the, you know.
Suspended the ceiling, whatever. I get the level, and that's all I'm asking. And I don't disagree that the septic should be at a certain level. Before I would support this. If I can make a further comment, I'd say, you know what? If I want to put a dryer or a refrigerator or something that gets flooded, you know, it's my loss. I'm stupid enough to do that. You know, that's all I can say. So, if I boats or tins. The hazardous material, I believe, get them off those levels.
Anyone else? Okay, I guess that's your feed.
The other section, which, again, if committee members had any comments, I'm happy to hear them. You can flip to the very last page. It's with respect to economic growth, questions 27 and 28. Very different topic, obviously, but a lot of what you'll read in the background paper, a lot of our economic growth will consist of home-based businesses and home-based industries. Unlike perhaps certainly other urban-type settings or other municipalities, we have not historically pre-designated or pre-zoned areas or properties. Evely Park is one of the rare examples where Evely Road is one of the sort of rare examples where a previous official plan did identify that as essentially the industrial park for the township. But two of those questions really revolve around, again, committee members' level of support for home occupations and home industries, and two, whether we want to be even more proactive and actually identify areas where certain construction or contractor yard type businesses should be located. This came up, I believe, in the discussion, certainly with staff and the consultants, and I believe at the working group meetings. We receive a lot of development pressure for contractors' yards. It's a very big industry in the township, obviously construction. And there's a lot of pressure for visibility and exposure, particularly on the main highways, 118, 169. And you're starting to see a patchwork of them along those roadways between Port Carling and Bracebridge in particular, Glen Orchard to Port Carling. And right now, I think staff, I can speak for the three of us, or four, that we sort of are concerned about the hodgepodge approach to that. The current policies are generally supportive as long as they're appropriately located. But I think we're seeing a lot of that development where I think some more proactive policies need to be put in place, and perhaps actually designating areas where we want to establish those types of uses. So again, just it's a bit of background. If there were any comments on questions 27 and 28, again, I'm happy to pass those on to our consultants. I think in the document there must be a formatting error. The 27 is squished, but if you go to the very back, they summarize all the questions, and it's 27 and 28.
What page number?
Like 100 in your agenda package.
No, but if you look at the very back page, page 132.
132?
What's our agenda package?
Yeah, the agenda package number.
Getting there.
Okay, we'll figure that out in the meantime, Councillor Nishikawa.
Sorry, it's page 380.
Thank you. David, I'm trying to make sure that I'm asking that, or basically you're talking about policy. And so when we have in the past discussed, for instance, way back when off of 118, a property owner brought forward a proposal on his property, and we had said we want it 100 feet back off of the highway. We want that tree buffer. Is this the type of comment that you want? Like, is this what we want to say, for instance, when it comes to contractors' yards? Is that the direction, the quite specific direction that you're looking for? Because I guess where I'm confused of whether this is going to be more of a bylaw issue or if it's an OP issue.
Generally, yes, I think that type of direction is probably even more detailed or specific than we need to be. Maybe to put it in a bit of perspective, as I said, if you read the economic growth background section, it breaks down the typical industries and their percentages in the township, and certainly identifies that home occupations and home industries is a portion, and certainly is projected to increase in the future, that more people will work at a home or not have a single place of work. And it's a general question, is our committee members generally encouraging that type of future economic growth? And then I could feed that back to the consultants so that when we meet with potential policy directions, you may find some options on how to support it. including conditions such as increased setbacks, and these are the things we want to see if it's to occur, versus the alternative, no, we don't want to see these types, and I'm happy to forward that message back, in which you might see a different set of policy options when we meet on April 3rd. So that hopefully puts in a little perspective of the feedback I'm trying to get. So again, the consultants are using this as a sounding board so that they can put that document together and give you options for the sort of feedback you're getting on these questions. So.
Follow up?
So essentially, I feel that in most cases, they should be off of a main corridor. Very important, because it actually is less harmful for the environment in general, but also what that buffering should look like. So again, I was on council when we approved a property on 118, and actually we didn't have the right policies in place, but even the applicant came forward and said, well, if you give me this, I will give you better buffering, and we didn't take them up on it. So it's one of those situations that I hope moving forward that we can generally put that policy in place, that we expect all of these types of properties. But I think it's very important to come off of, off of a highway or a major corridor.
Councillor Roberts?
This is not really on that topic, or it's skirting around it. Throughout the document, the cosmetic changes in that, the consultant talks in Part A and Part B about policy considerations. The new part talks about policy, in some cases, it has policy directions and policy considerations. So just a question, I'm assuming that all the considerations are actually policy directions. Because, on the index, on section 16, it says list of policy considerations, and it includes the policies that are under a docking that are all policy directions. So I'm just saying, is a policy consideration a policy direction? Then I have a supplemental. I would think so.
Generally, I think generally, short answer is yes. I mean, eventually they will formulate policy directions with similar type of wording. At this stage, I don't think anything's a final decision or answer to go to the public. I think it's, again, more feedback to the consultant as to, again, 26 in particular, 28 is a fairly simple concept to wrap your head around. Our committee members generally supportive of home occupations and home industries is that. And then future more specific policy direction will flow from that at the next meeting.
So I'll let you get back.
But you're not tied to any particular comments today.
So follow up, I'll let him get back to what we're talking about right now, but at the end, I'd like to make a comment when we're finished this section.
Councillor Mazan?
Thank you, and through you, Madam Chair. Specific to those particular ones, I would say a conversation around the Economic Development Subcommittee has been finding ways to encourage lower footprint kind of businesses, which often leads us to a knowledge-based economy, which would lead us to maybe more of these smaller home businesses. So it has been a conversation that's been had around the table, and thus the conversation yesterday about the importance of broadband and internet, where the future is and the types of businesses that might be able to, the type of people who could live up here and conduct business is shifting and evolving, and it is something that is being considered on committee. So if that's helpful, is that the type of direction? Okay.
Anyone else? Okay, so I agree with Councillor Ishikawa. I think off of the major corridors keeps it out of the other roads too. And I don't know, can we actually zone certain areas throughout the township for contractor yards? I think that would be great. It's sort of like our Evely, that's our industrial park. I think it would be nice going forward to have those identified. Councillor Nishikawa?
I don't think that it's that easy, though, I will say, because just to go and sort of blanket I'll just say all of the acreage properties along 169 and 118, it isn't necessarily, I think, I would say a whole lot more thought and a whole lot more opportunity exists to, so for instance, I'll just use Hardy Lake Park as an example. A past council decided that where there was zoning in place this goes back to 89, they recognized the lands next to the park. The ideal use would have been for a motel, that type of thing. In fact, it's now become a contractor's yard. In fact, it was supposed to be home first and secondary contractor's yard, and then that got also removed, the home part of it. So certain areas where we respect, for instance, a park, or if we're talking about any of our gems, I guess, I wouldn't like to see that we would just blanket, okay, there's a 100-acre corridor, like, let's just give them all these rights. I think it has to be a little bit more detailed than that, and I think it's going to be quite an exercise.
Oh, no, I agree with you. I didn't mean blanket things. I just assumed that let's look at places that would be logical. That was it. Anyone else? Okay, Mr. Pink, did you have one other area? All right, I'm going to read this then. Moved by Councillor Roberts, seconded by Councillor Edwards. Be it resolved that Planning Committee recommend to Township Council that the final discussion papers be received and that the existing resort policy framework be reviewed as part of a future joint comprehensive planning process with the District of Muskoka. Any discussion? Councillor Roberts?
I can't support that as written. It has to include the working committee input before it goes to council. So, all right, so I will not approve that. We have we have public who have come in, spent many hours. Their input has to go in that document or be given to the consultant prior to going to council. If we can get that done, then let's get it done. We don't need a meeting, but we need to hear from them, in my opinion.
Okay. Councillor Edwards?
I support, and that Councillor Roberts, I think the working group, we should not bypass them. It should go back to them first and then come to us. That's my thought. So I would not be supporting this.
So what we were talking about before, where Mr. Pink can receive comments and then that comes back to the working committee is fine? We want that in the resolution? Because I think we've already decided that's going to be done, so. I do feel like this is the time to tell a story, but I don't have a story to tell.
Oh, don't get Alan started.
Councillor Jaguar?
Maybe I could just fill in the time. I'm just trying to understand how that would work in the document. Are you suggesting there's a section that says committee comments, or how are you?
Go ahead.
Through you, Madam Chair. No, this is, as Director Pink pointed out, this is a sounding board. As a sounding board to the consultant to see if they're hitting the mark. So all we're saying is, in writing from the working committee, give a sounding board back to Mr. Pink. Then he can forward that on to council before, this is February, right? March, okay? So give them a timeline, 5 days or something like that, and just get it done.
In a separate document?
In separate emails, but not in here.
Not in here.
Yes. Okay. Okay, it's been amended to township and that the final discussion papers be received upon review by the official plan working committee and receipt of any comments, and that the existing resort policy, the rest of it goes on. So, we good with that? All in favor? Opposed? Carried. Okay. All right, thank you. I think we're on to long-range planning, which would be site plan agreements. Mr. Allen, I think you're up again.
Thank you. If the committee may recall, in November, questions were raised about the site plan approval process and enforcement in the waterfront area, particularly on waterfront residential properties, and there was a number of concerns that were identified. Following a lengthy discussion, the committee directed staff to undertake a review of the current process and procedures and offer suggestions and recommendations to potentially improve and enhance the process. And specifically, Member Roberts had indicated if money was no object was the term that was thrown around. So staff have gone to the effort of preparing an information report for discussion purposes. I think it's important that it's a very challenging exercise to go through when money is no object, because ultimately it always is. So we did have to ground some of our recommendations in common sense. The township was not going to acquire a satellite to monitor everyone's property. So that would be an example of an over-the-top recommendation. So our report touches on a number of issues, but I think and includes a range of suggestions and considerations, but I think the most important part is that it's for informational purposes to generate discussion, and any potential changes should require further review and analysis, and particularly public input should be considered. And by no means is this an exhaustive list. We could have spent months and months continuing to brainstorm and putting together suggestions. So at this time, we're not recommending any implementation of the suggestions because there is clearly a wide range, but ultimately we grouped our suggestions or recommendations into 7 different categories. The first being site inspections, the second being owner reporting requirements, the third, security deposits, fourth, protection areas and barriers, number 5, signage and notification, number 6, independent reviews, and number 7, tree inventory, number 8, timing, and number 9, sewage disposal systems. It's a very lengthy report, and there's no intention of me going through and reading all of the suggestions. It's attached to your agenda package. You can find it on page 432. This is meant to generate discussion. Staff are more than happy to listen to your feedback, but ultimately the hope is that this results in some kind of changes to the process after some thoughtful consideration and deliberation. Obviously, there is budgetary expenditure, staffing levels, a number of issues that must be considered, but this is a good place to start with what we've laid out here. So we're happy to take feedback and happy to listen to any suggestions, ideas you may have.
Thank you, Mr. Allen. Any comments at all by Councillor Nishikawa?
So years ago when money did matter, I guess, we heard around the table that how difficult it was from a staffing perspective for our planners to actually follow up on the plan. And so it was actually part of a discussion when we decided to go to hiring a full-time bylaw officer and what expectations, like could we share the bylaw officer with the building department, or planning department, I should say. And I don't expect a staff member necessarily to answer me. I just really would hope that there would be a further way to involve bylaw that we haven't done before. And I'll leave it at that. For further discussion, I will have a discussion with the CAO or something in that realm, because there was reasons that council at the time went to the direction, like, it was a change in direction, certainly of how we ever dealt with bylaw officers. We would just hire them for the summer months, more or less, and then we went in a different direction. And then that direction even got morphed differently than we expected. So mostly, as I said, I just don't expect our current level of staff to fill in all the missing links, and that's why I want to use our bylaw officer more.
Any other comments? Councillor Mazan?
My comment is simply, this is very helpful, and I would say thought-provoking. So just a compliment, I think, to staff. You know, I'm rereading it and letting it absorb, and as we look forward to possible new solutions. I mean, I think down in number 7, we talk about sewage disposal systems, and you have some suggestions in there. I don't really have any specific comment, other than I'm grateful for the thinking that's gone into this, so.
Did I have over here? I can't remember who was first, so Councillor Roberts?
Okay. I think it's a very good report. There's a lot of detail. I certainly wouldn't recommend we go to the extent of everything that's in there. I'd be more on the idea of using a site plan with securities and a follow-up. And the two areas I'm interested in are tree removal and blasting. And if there was some way of wording it at the waterfront, sorry, within 200 feet of the waterfront is the main concern. And therefore, if there's some way of requiring a site plan when there's tree removal or blasting over a certain amount, you can't obviously, if somebody wants to take down a tree, that's fine. And that they have to get that site plan before they do it, and they provide a security for what they're going to do, and then it's a follow-up after to see that they've done it. And then if they haven't done it right, then maybe there's a 6-month delay in getting their building permit or something, you know, but just some idea that there's some thing. And I don't think we're after the little guy or somebody that wants to build a garage or something like that. We're after the big abuses that we see, especially on the waterfront. So I would tend to, but I think it is going to involve some more staff. Someone's going to have to go out to the site ahead and have a look, and someone's going to have to go out and follow up. So I think we have to do that. But maybe we should look at how our bylaw officer, you know, that would have, I don't know how that takes place, but anyway.
Councillor Roberts, no.
Just quickly, just to bring in context, the statement I made, cost is known. It shouldn't be considered. What I meant by that, and you've done it, is to, within your expertise, what are your ideas? Don't at this time say we can't do that because it's not reasonable. But if you can write down an idea, and then what it does, the team looks at it and say, well, maybe we tweak it this way or that way, it'll be a good idea. So this is just like a very first cut at this, and it gives a great insight, and I think we need to follow. Now that you spent the manpower, which I understand was considerable, we can't let this just go. We have to have next steps on this, i.e. council needs to, or have a little focus group that sort of looks through this.
Mr. Pink?
Thank you, Chair. I just provide a few comments, and I would commend Ryan. It was an excellent report and a lot of great ideas, and I think it was a good exercise. I wouldn't necessarily mean to imply that any change has to come and get direction from council. I think this was just a great exercise for the three of us to sit down and chat about ideas. And I think you may have heard me say that Caitlin's new position is really largely to take on some of these issues, and that's why that position was retained. You'll hopefully see a site plan control bylaw update in front of you in the near future, which will require more site plan approvals and more of these types of activities. So I think staff certainly can pick through these and implement ones that we feel are certainly reasonable. It can just be done as a matter of course. But as Mr. Allen indicated, I think any more significant changes that's going to have staffing implications or certainly significant impacts on the development industry and the community at large, certainly we would come back and have to get direction from council on that. But there are certainly some good ideas in here that we plan to implement largely as a result of the new position that council approved last year.
I'm sorry, Mayor Harding, I missed you.
No problem. Thank you, and thank you, Ryan. Extremely detailed. You know, we say money is no cost, but at the end of the day, when someone's doing, we sat this morning, we were imposing because of our bylaws site plan control for a covered porch that was already built 15 years ago, and yet now they had to go through and provide that. And if we implemented Section 6, now that has to be independent peer reviewed and done. Sometimes we may get a little bit ridiculous in what we're asking for. And I will say, and I agree, there's some people who just blast everything in certain properties, but I think the other reality that we do face, many of our lots today, for someone to build a cottage, the flat level beautiful lots are long gone, and so newly created lots may have more challenging slopes. They're not ideal, and sometimes blasting may occur. And I know I've had a number of people walk with me through our blasting bylaw. Our chief building officer and I went through it a year ago to what we could do or couldn't do, and then there's certain amounts that are in our existing. I'd encourage everyone to look at our existing blasting bylaw or site alteration bylaw, excuse me, not our site alteration bylaw, and some of the other blasting bylaws. But when it talks about pulling out some rock and the amount of rock, you know, again, as a construction crew gets in to do some work, and they're going, they realize as they scrape away the earth, which they don't know until they start to do it, there's one little corner of the foundation that I got to blast a small little piece. And do we stop? They got to come in here. We have to review the blast, and we potentially stop construction for 2 or 3 weeks until we can process through what that blasting is and our staff implications. And there's contractors there to frame and pour concrete. So there's a number of issues that potentially come with it. So I'm not against it, but I'm just, as we integrate that into site plans, and again, we're doing more and more of these things. And let's protect and let's make sure they're following. I mean, I love some of these ideas that we have to post a site plan. I love some of the ideas that those people who are working on the site sign off that I'm going to agree to the site plan. Those are some very simple things I think will help us immensely. So, great work.
Thank you. So one of the things I liked in this too was actually marking on the property where they could blast and couldn't, what the protected areas. I don't know how realistic that is. You'd have to tell me, but in orange tape, take a picture of it, so if you go back and you see it's been moved. I just liked that idea too. So, and I know that's more staff involved, but there was lots of stuff there, so. Okay, Councillor Jaglouis?
Yes, I'd just like one more comment through you. And this may be more for our official plan, but, and I'm just going to refer to a property, I won't name it or where it is, but about 30 years ago, had a lot of rock on it, and they built a beautiful, beautiful, beautiful place, beautiful boathouses, tennis court, but they fit it into the terrain. They fit it in properly, and it was a large lot. And then when it was sold, people then tore everything down, and then in order to accommodate and split it into two, they had to do a tremendous amount of blasting, okay? So we should be thinking about whether that should be permitted. You know, that's maybe people are going to have to learn to build within the terrain that we have. And that's what I'm talking about. Before they blast, they come in and they ask for a site plan, and they say what they're going to do, and there'd be some discussion on it. Because I don't think we're trying to affect someone that builds a house on a fairly flat lot and goes down and hits bedrock and has to blast a little. I don't think anybody cares about that. So that's my comment.
Councillor Edwards?
Yeah, you know, you've got to have some rules because as we see in that people like we had at the Committee of Adjustment where somebody had a boat port, they had been turned down about 3 or 4 times, and lo and behold, it's built without permits and everything else like that, and of course, you know, it's there and it gets approved. I think we've got to get the contractors involved. I think if we're going to, we had one at the Committee of Adjustment just the other day where somebody said, oh, it was there when I bought, but they brought the air photos in and of the years, and guess what? So it was done, and we turned it down because, like I say, they've just basically clear cut and everything else of that. So, you know, I think there are tools now that we can do, and I think in that if they're coming in, maybe we should check the air photo at that time and follow it from there. But we've got to do something. It's only about 3 or 4% of the people that do it, but we have to have rules. It's like speeding on the highways. You have a speed limit because there only, you know, some will be going 240 kilometers an hour. So I think we should look at that. I don't know what the answer is at this point, but I think that, you know, if we're going to get serious about this, then, you know, we have to take a hard stand.
Okay. Anyone else? Mr. Allen, Mr. Pink, any comment?
Just maybe end on a positive note, two comments. One, construction never looks pretty. You know, in the city, they put up hoarding, and we always get the complaints when building permits are issued, trees are coming down, land grubbing. But the value of land and development in our township, typically the finished product is tasteful, and over time it does mature the vegetation. But just to end on a positive note, I mean, given the amount of development pressure our municipality experiences and development that occurs, you've seen the building permit data on the year-end reports, I think we do an excellent job. There's a lot of development occurring, and the vast majority of it is tastefully done, properly done, with agreements in place, proper approvals, and landowners do abide by their agreements. We tend to focus on the few bad apples that draw all the attention and all the negativity and all the comments. But I like to believe that it is few and far between. We have an iconic brand, and it continues. We've seen this development pressure now for decades. This isn't just the last few years. I've been hearing it since I've been here and before. And we continue to grow and grow at a remarkable pace, and I think we are doing an excellent job due to staff that we have here controlling the development that we do see. So just thought I'd end on a bit of a positive note. We will certainly, I think this was an excellent exercise, and we will take some of these suggestions and a lot on Caitlin's shoulders.
You're not allowed to go out the door, Caitlin. You're not. So, Councillor Edwards?
I noticed in the actual report there was something on grandfathering. That's something we should look at, because if something's been torn down by somebody else buys it and says, well, I've got in that grandfathering rights, because, you know, I think we should be looking at some of that. I think there should be, I don't know if the Director of Planning can comment on that, but I think there should be a timeline on some of this stuff.
I believe that's one of the questions and in the report. So we will be dealing with that. So, and to your point, Mr. Pink, I mean, this is a great, and we do understand it's a very small number that are abusing this, and you keep most people in line. We really appreciate that. Yeah. So, okay. No more comments on this? Okay. Okay. So, sorry? Yes, okay, yeah. All right, Mr. Pink? Thank you.
On page 722 in your agenda packages, committee, just a very brief report on last year's development activity, planning application-wise. As noted in the report, it's holding pretty steady compared to previous years, and a bit of an outlook for what 2020 may bring. Just keep it brief and self-explanatory. Happy to answer any questions.
Yeah, it was really interesting. Thank you. Any comments? Okay, yeah, that is brief, but really interesting. So, thank you. So any questions on the staff delegated approvals for site plans? No questions. I'm going to move on then. Our LPAT report.
So I would like to update committee on the LPAT decisions. We have been putting this link on the agendas for a few months now, and there are certain periodic updates. You don't have to wait monthly. They are available through that link on the LPAT website. We did receive a decision for the PJD Properties, Inc. I believe that was definitely a previous term of council. Those may recall it. It's since changed hands. That was the prior owner's name. This was on Reef Island of Lake Joseph. So you see the LPAT decision was reached. And yesterday I received two decisions, which I'm happy to talk about or field any questions. One was in the name of Evans. That's a subdivision on Camel Lake. I think most members are probably familiar with. The tribunal did approve that plan of subdivision. And the third was in the name of Noonan McIntosh. That is a application for consent, official plan amendment, and zoning approval on Leonard Lake, the new proposed lots on the North Shore. That decision was, or those applications were approved by LPAT as well. Just received those decisions yesterday. They will be available on the website if you wish to review them. And again, happy to field any questions that members may have on those three or any other LPAT matters.
Mayor Harding.
Thank you. Maybe we can just highlight, as I'm trying to read through the bylaws specifically on Reef Island. As I look at this, I'm assuming they got as two voters as PJD. They got what they asked for. It's as simple as I can say it. But any other real modifications that I'm missing?
Mr. Pink.
No, they did essentially receive, thank you through the chair, what was applied for, but certainly there was extensive negotiation to get there, and the ultimate layout of docks, boathouses, and the cottages was certainly refined and reduced somewhat from the original proposal. But essentially, in the end, the general number of habitable buildings, 2 dwellings and 2 sleeping cabins, situated above 2 two-story boathouses, was approved.
Okay.
Anyone else? Okay. Now I think we're down to Councillor Nishikawa.
Thank you. I just have one question or thought to David. So again, I'm going back years. There was sort of a study of, and it's some of it is here, but basically how many times we lost on a certain situation. And also, like, how many applications are coming forward to always get that extra 1% or that other, and ultimately, I am wondering if at some point this council should be revisiting decisions that we put in our bylaws and decisions that we do, but yet we keep getting pushback from the public. At some point, do we just acknowledge that we should move our meter a little bit? And that's all. Because when we put some of these things in place, it was when we didn't have great working septic systems, and we are much more refined in so many ways, but it's just, I don't know if you're getting where I'm coming from, David, but at one point we did have that exercise where we kind of looked at how many applications we got on one particular topic, and then we would make some adjustments.
Would you like to comment, Mr. Pink?
Sure. I think it's touching a bit on the planning department activity and perhaps the official, and certainly the official plan review as well. I don't have LPAT stats as to our success rate, but off the top of my head, it's certainly typically staff's recommendations are typically the outcome in most cases. But I think looking forward, the broader issue, what you do typically during an official plan review and zoning review is certainly look at your most common applications. And I would say it's no surprise, lot coverage, probably number 1 or 2, and your setback from the lake. And those are certainly areas highlighted in the in our discussions with the consultant, and will be, I presume, heavily debated topics during the official plan review as to what direction we go with those two topics. Always heavily debated that grandfathering of setbacks from the lake, because that's a lot of the redevelopment we're seeing. And then second, lot coverage and the pressure we receive for greater density. Always a push to build a little bit bigger and a little bit bigger. And I think we need to look at those two issues potentially a little differently going forward. So like I say, it certainly will become part of the OP discussion, I'm sure.
Any other new business? Okay, then I think we're ready. I'm going, moved by Councillor Edwards, seconded by Councillor Roberts, be it resolved that Planning Committee adjourn at 2:15 p.m. and the next regular meeting of Planning Committee will be held on Thursday, March 12th, 2020 at 9 a.m. in the Council Chambers, Municipal Offices in Port Carling, Ontario. All in favor? Thank you, everybody. It was another long meeting. Thank you for your indulgence.
2 hours short of council.
Done.